Chief Justice पूछा
ಇಷ್ಟೇನಮ್ಮ ಇದು ನನಗೆ ವಾಪಸ್ ತರ್ತಾ
Lordship, MFA mallet has been disposed of. And there is a typographical mallet decree branch noted for being spoken to on Monday.
Lordships, this is the matter wherein your lordships had directed for an evaluation to be conducted by Nimans. And there was specific directions from your lordships to list the matter today to the registry. The matter has not been listed today. There is great urgency in the matter.
Monday we will.
Please. Grateful.
Find out why it is not listed.
Grateful.
Yes, page wise.
Page-wise adjournments. List 1, page number 12, serial number 30 to 37.
Number 30, my lordship.
1 minute. Page number
12.
serial number
30 to 37.
30. You are for the
Respondent.
who moved the memo?
Petition. I have moved the memo, my
It
lord.
is Siddharamaiah.
For the petitioner in this case.
What is your urgency?
My lord, I'm seeking a transfer, my lord. It's
There's a stay in this.
Please, my lord.
All the matters have to be disposed of before vacation. Why you want time?
Filing objection, my lord.
When did you file your wakalat? It's a 2024 matter.
Please, my lord.
We'll see. We'll see. No, if your objections are required, we will adjourn the matter. Be there. Yes.
Page number 13, serial number 39 to 44. Page number 15.
44. Oh. No, I said these matters won't be taken up now. 43, 44 and 45 after vacation.
Yes.
Give some date. Yes.
List number 1, for being spoken to serial number 1. Or in Gautam Raghunath.
Appear for the petitioner in the main matter, my lords. May be permitted to pass this over to your lordships. The correction that I seek, my lords, is in respect of the judgment that could be looked into, my lords. Passed by my lords on 29th of November 2024.
Yes.
Page number 3 of the judgment, my lords.
Page number 3.
3 of the judgment. At para number 3, my lords, the daughter is presently aged about 15 and not 12 and a half.
15 years.
Yes. Next is, my lords, page number 31.
Page number 30.
31, para number 24, my lords. 1, 2, 3, 4, 5. Sixth line, my lords.
1
It's-
minute.
Yes, please.
Paragraph number 20.
4, sixth line, my lords.
Uh,
It says till 2020, it is actually till 2019. My lords, then the clarification that I seek before your lordships is in respect of the visitation rights
Oh,
in,
it is
these are two typographical.
3 and 31.
Please, 3 and 31, page number 3, para number 3, page number 31, para
Paragraph
number
number 24.
24,
Yes.
fifth line.
Yes.
One is the prayer, clause 1 and 2, my lords. The clarification that I'm here before your lordships is as to what the visitation is it supervised or unsupervised? Because I have initiated execution proceedings. The execution proceeding, though it does not come on record, though they don't state it on paper, but they make it sufficient that it is
No.
supervised.
Here, when the order says, whatever I didn't say supervised, that is unsupervised.
Please, the reason is, my lords, the submissions that are being placed before the trial court in the execution proceedings are that it is supervised. So what's happening is, well,
The
these
father
two
can exercise a visitation on
never
every
placed
Sunday from 10 a.m. to 4 p.m. He can pick up the daughter from the
Please.
mother's place and take
Please.
her to his house or any other place where the girl is comfortable. Nowhere the court said it should be the mother should be there.
then I can, I'll advise the client
I've
considering
never made that
Because
submission
I'm
also,
still
Your
not,
Ladyship,
I'm
that it
still
has
not,
to be
I'm still not, I'm still not.
Anand,
So, sixth festival, my lords, that clause number, well, is all father is, I mean, the festivals that my lord state. Well, there are some festivals where there are no holidays. So all
42 எதுக்கு பண்ணீங்க?
this is to permit the father to pick up the child at 2:30 p.m. and drop the child back at 8:30 p.m. at the mother's place. Because my lords, all Sikh
Where
festivals
do
are
you
not.
get that?
Clause number 3, same,
Order two.
page 34,
The
clause number
father-
3, clause number 2.
The father on important festivals in the religion can exercise a visitation from 10 a.m. to 4 p.m.
The problem
if it is
being
if it is a working day after the school hours.
Please.
For,
And
that we will
she shall drop the
clarify.
child back at the mother's place. My lords, also the other fact that I would request my lords to consider is clause number 3 of the prayer. The father is entitled for 50% of the custody of the child on all vacations. My lords, as per the parental guidelines, the non-custodial parent is entitled for the first half of it. I have not been given. My lords, in fact, since this judgment was pronounced in November 29th, I've sent several emails.
Oh, please understand.
Please.
Now, either this is a for being spoken to. In
Correct.
this, the court cannot consider
Please.
all these things, number one.
Please.
And if you have filed a review of this order, you would have got an
SLP.
opportunity to
SLP
file
is
these
already-
objections to that.
No, they claim that.
No, no, as you said, the other two, I can understand.
please.
Even this two also, court can understand, but it requires a clarification. But other things, if you're saying on what was not done and what you're entitled to,
Please.
for that you need to file a review, not a for being spoken.
My lords, review because my lords per se did not find anything wrong with the order, my lords.
No, but
That
that
being
you
there is
wanted-
no
you
error
wanted-
apparent on the face of the record is what the scope
But
of
I cannot
review is, my
clarify,
lords.
I cannot clarify all that
Yes,
in this.
please.
I said 50% visitation, whatever as per the norms you are entitled, you will get it.
My lords, I totally concede to your lordship's directions, my lords. I do not really for a moment do not say it's wrong. My lords, the problem that the father is facing here is, my lords, one is whatever order was pronounced, my lords, it's not being followed since December. Now I initiate execution proceedings. They come and they come and they submit their umpty number of things which do not which does not find its place on paper. They say no, it is they say no, it is supervised, all of it.
Nothing
What's
of
happening
that
is, let
sort
me
has been
complete, so please let me complete.
Understand the order, I think.
Yes.
By whatever the respondent
Obviously.
says,
Please, my lords.
court should understand the order.
Please, my lords.
You should read the order as it is.
Yes. Your Ladyship, in fact, it's today because we filed an order 21 Rule 26 application. The diary number has been given. This matter has now before the Honorable Supreme Court. That's all we have done. And we have initiated and facilitated, even without your Ladyship's orders, birthday we facilitated. But the same behavior was repeated. I do not want to go into those things.
My lords,
And all these were discussed. I have not made these submissions at all, whatever he's suggesting.
my lords,
Supervised,
I shall leave it
unsupervised,
to
no,
the,
we have not done it.
I shall leave it to the trial court, my lords, in respect of that,
Fact, he's
because
not
we know what's
appearing there. It's
happened, my
part in
lords will not
person.
do.
Are being spoken
Page
to-
31 is still August, my lords, page 31,
Those two
31, para
typographical
number
errors.
24, what I'm,
Paragraph
it's
number?
page 31, para number 24, I've stated that 2019, right, my lords? It's till August 2019.
Correct.
That
Those
needs to
two
be
are
corrected.
typographical errors. for
Whereas
sure.
in respect of the clause 2 at page 34, my lords, of the prayer, what's happening is, my lords say that he can pick up the child. If my lords could at least say that he can pick up the child, I would be grateful, my lords, because that would in fact sort out all the issues.
Now-
It only says the father on important festivals in their religion can exercise the visitation. My lords, each and every preposition, everything is being used in a different, interpreted in a different manner before the trial court, which is the difficulty that I am facing very frankly, my lords.
Now,
I leave it, my
may-
lords.
May I
discretion.
submit? Please, you have yourself, ladyship, put a rider there about the comfort of the child. Please appreciate this. This was the bone of contention there also. Our contention is any public place, anywhere he wants to facilitate, we are okay. Unsupervised or overnight is the problem when he is in person or he's alone with the child. Now, this is already raised before the Honorable Supreme Court on this aspect because that is a tandem. Both the courts have mentioned this. Otherwise, you need not have given daytime custody and overnight custody. It could have all been overnight custody. So the wishes of the child is the moot question now before the Honorable Supreme Court. So let us not disturb this.
Please come
Those two typographical errors, I concede.
for this court and for being spoken to. It is submitted that at paragraph number 3 of the, paragraph number 3 of the order, there is a typographical mistake. Instead of mentioning 15 years, it is mentioned as 12 and a half years. Then at paragraph number 31,
Page number 31.
24.
page number 31,
Para 24,
paragraph
sixth line.
number 24, it is stated, it is mentioned that till 2020 that order was with the father, but it is till
29.
August 2019.
Please.
Highly obliged.
It is submitted that in the order, the in the operative portion of the order at clause number 1, it is mentioned that the father can exercise the visitation on every Sunday from 10 a.m. to 4 p.m. He shall pick up the daughter from the mother's place and take her to his house or any other place where the girl is comfortable. And clause number 2 is the father on important festivals in their religion can exercise the visitation from 10 a.m. to 4 p.m. It is submitted that when they have filed the execution petition before the trial court, it is the case of the respondent that the court has ordered for a supervised visitation. As such, a clarification is required.
May my strenuous objections
No,
be
that
recorded?
is his case, and the supervised visitation is according to the mother, it is supervised visitation. Then it is stated that this court has permitted the father to exercise the visitation on all whatever from 10 a.m. to 4 p.m. on all the important festivals. It is stated that on all the important festivals, if the girl is having a school, it's not possible to exercise the visitation between 10 a.m. to 4 p.m. Land counsel appearing for the respondent submits that they have questioned this order. They have assiled the order impugned before the apex court, and the same is yet to be listed.
Diary number was given
Huh?
today, yet to be listed.
That is yet to be listed.
They are on
It is
page.
submitted that they have never raised any objection that it is a supervised visitation, and without any basis, the submissions are made. Next para. The order as far as paragraph number 3 and paragraph
20.
number 24 are concerned, accordingly, the age and the
Here.
age and that till August, it should be read as August 2019 at page 24, and at para 3, it should be read as 15 years. Then coming to clause number 2, the father can, on important festivals in their religion, can exercise, clause number 2 shall be read as the father on important festivals in their religion can exercise the visitation from 10 a.m. to 4 p.m. And if the festivals fall on a school day for the child, it shall be between 4 to 8.
Well, it's 2:30 p.m. to 8:30 p.m. I will pick up the child from the school.
School is between what time?
School is what time?
Till
Till
2:30.
4 o'clock. School is till
Till
4.
2:30.
After school hours.
After school, between 4 and 8, accordingly, the registry shall issue the amended order.
Highly
I request
obliged.
this order to be uploaded. Then
Uploaded, it will uploaded on Monday.
Yes.
My lord, because the execution I shall have to, I have to produce.
Monday
this
it will
one.
be uploaded.
Great.
Yes.
Apply, lords.
Serial number 2, parted Pallava for petitioner.
Waives petition seeking transfer, restitution of conjugal rights initiated by the husband at
Use the mic.
the petition by the husband my lord, seeking restitution of conjugal rights filed at Bangalore. Wife is seeking transfer to Mysore. My lord, distance is about 150 kilometers. It's two children, my lord, two minor children. One is age 7 years and the other, the girl child is age 1 year. Therefore, my lord, transfer is sought.
Last occasion, what happened?
My lord, in fact, my learned friend, my
They were
lord,
not there.
they were there. They said they would seek instructions and they would say no
No
objections. Yesterday,
representation on behalf of the respondent.
respond.
Then counsel the petitioner is present, Mrs. matters parted. The present petition is filed seeking transfer of MC number 7135 of 2024, pending on the file of the second additional principal judge, Family Court, Bangalore, to the Family Court at Mysore. The facts are the marriage between the parties was solemnized on 18/11/2015. And in view of the differences between the parties, the petitioner started residing at Mysore along with her parents and the children who are aged about 7 and 1 year.
1 year.
1 year. Thereafter, the husband had instituted MC number 7135 of 2024 on the file of the Family Court at Bangalore, seeking restitution of conjugal rights. Has she filed any other petition there?
No, no, ma'am.
So it is submitted that the wife is residing at Mysore and the distance between both the places is about 150 kilometers, and it's difficult for the wife to travel. Further, she has to take care of the two children who are aged 7 and 1. Next para. This matter came up on came up on 16/4/2025, and as there was no representation on behalf of the respondent, the matter was directed to be listed today under the caption part third. Today also there is no representation. Hence this court is obliged to pass orders on the merits of the matter. The MC is instituted at Bangalore and wife is residing at Mysore along with two children aged 7 and 1. And the distance between both the places is about 150 kilometers. Considering the inconvenience as being caused to the wife, this court deems it appropriate to allow the petition. Wife shall cooperate with the trial. Yes, next.
Great.
Number 3, Kiranath, Dhanushri, Bimbadar.
Your Lordship, this is a petition filed seeking transfer from Bangalore to Shimoga, my lord. OS suit filed by the respondent husband for recovery of 1 crore rupees, my lord, as a compensation, my lord. My lord, the petitioners are permanent residents of Shimoga and the distance is about 300 kilometers, my lord. And the petitioner number...
What is the relation between petitioner and the respondent?
Petitioner number 1 is the wife and the respondent is the husband. Petitioner number 2 and 3 are the parents of the petitioner, my lord. The OS suit is filed against all the petitioners, my lord. Seeking recovery of 1 crore rupees as compensation, alleging verbal assault, my lord. My lord, the petitioner number 1 has filed the two petitions are pending in Shimoga.
They are divorced or they're
My lord, divorce petition is pending in Shimoga and another one is a domestic violence case pending in Shimoga, my lord. And the divorce petition was filed by the respondent before the Bangalore, my lord. That was transferred by this honorable court to Shimoga, my lord. As
filed here is transferred to Shimoga.
Yes, my lord. Yes. And my lord, it's a matrimonial dispute and hence it was transferred to Shimoga, my lord. My lord, it's just filed just to harass the petitioners, my lord, seeking compensation.
My lords, if I kindly see the averments, my lords, it was a suit of the year 2022. My lords, almost for 3 years they have taken the proceedings and the courts at Bangalore, my lords, has invested its precious time, and my lords, the proceedings have been reached the stage of cross-examination of plaintiff witness number 1, and PW1 is being partly cross-examined now. Now the matter is posted for further cross of PW1.
What were you doing from 2022 till 2025?
Your lordship, pleadings are now completed and it is just begin with the
suit is of the year 2022. If you wanted a transfer, you would have come before the court much earlier. You have submitted it to the jurisdiction of the court and you were appearing before the court.
My lord, we entered appearance in the year 2023, my lord, and we were,
From 2023 to 2025, also still 2 years.
my lord, the pleadings are just completed and it's just at the stage of cross-examination. My lord, one humble submission. My lord, there's a, the
When
dispute
was the transfer from Bangalore to Shimoga?
2024, my lord.
When is the date?
11/3/2024, my lord. Your lordship may kindly come to annexure A, my lord.
Then you filed this when, this petition when? On 19, after 1 year. So whenever you feel like filing the petitions or you want transfer, it won't happen that way.
My lord, the petitioner is a school teacher, my lord.
Maybe court will not come to the rescue of a litigant who is not vigilant.
My lord,
Please
one
come.
submission. One submission, my lord. The subject matter between both the disputes are
Maybe.
matrimonial disputes,
What were
my
you
lord.
doing? What were you doing? Why did you let the court to proceed with the matter?
My lord, we
So
request
it
a
is
time
not
before the
about the-
trial court,
no.
my lord. My lord, one submission. My lord, as per section 7, clause D of the Family Court Act, my lord.
We
the-
understand all that. We understand all that. But still, the court will not transfer it.
My lord, this is a divergent finding. There's a possibility of
Please
divergent finding,
understand,
my lord.
it is not about the merits of the matter. It is about the delay. You have the court, you let the court to proceed with the matter. You have no right to seek for transfer. Whatever the circumstances that were prevailing in 2023 remains to be the same in 2025 also. What did you do from 23 to 25?
My lord, they were unable to come
The-
and file it, my lord.
You are able to file a petition in the last year before this court, but you are unable to file a petition for that till now.
My lord, it was the pleadings just complete.
But your present petition is filed.
My
seeking
lord, this
transfer
being
of-
the family dispute, every
Yes,
stage.
I record all
instructions
the,
is
because
required, my lord.
all your arguments will be the same. You already submitted.
My lord, just
The-
one submission, please, my lord. Divergent findings are possible because the subject matter in a OS suit is a ground for divorce in the divorce petition as a ground for cruelty, my lord. If two courts comes with a different opinion, my lord, then
When
both
did
are
you realize this?
interdependent, my lord.
If you realize it in 26 also, we have to transfer it. The present petition is for seeking transfer of OS number 1020 of 2022. Filed by the husband seeking compensation from the petition, from the wife and the parents. Pending before the third additional senior civil judge, Bangalore, to senior civil judge and chief judicial magistrate at Shimoga. It is submitted that in view of the differences between the parties, the wife, the husband had filed MC number 74,
MC number
MC number
148 of
74 of
24.
2015. What is that MC filed by husband?
My lord, 148 of 2024.
Hmm?
MC number 148 of 24. This was
The
Shimoga.
respondent had filed MC number 3049 of 2021, seeking dissolution of marriage. Thereafter, wife had filed a transfer petition, that's CP number 363 of 2023, before this court, and this court had allowed the same by withdrawing the MC from the principal judge, Family Court, Bangalore, and transferred it to the Family Court at Shimoga. And what about criminal miscellaneous? That's the only case pending.
Two cases, yes, my lord. Filed by wife, my lord. Criminal miscellaneous
Petitioner
214
wife
of
had
20.
filed criminal miscellaneous 214 of 2023 under the Domestic Violence Act before the judicial magistrate of first class, Shimoga, and the same is at the stage of evidence. When counsel appearing for the petitioner submits that even the suit is arising out of the matrimonial relation between the parties, and as already diverse petition is pending at Shimoga, this also may be withdrawn from the family court at from which court?
My lord,
From
senior
the senior civil judge court Bangalore to the family court at Shimoga. It is submitted that if this matter is not transferred, there is as the allegations in the matrimonial cases, and also that will have a bearing on this case. The suit ought to, so if the suit is not transferred, it would cause a lot of hardship to the wife. The land council submitted that as per section
7D, my lord, of the
7G
Family Court
of the
Act.
Family Courts Act. Family Courts Act, give it. So section 7D of the Family Courts Act. The family court shall have the jurisdiction in respect of a suit or proceedings from an order or injunction in circumstances arising out of a marital relationship. And if the matter is transferred from Bangalore to Shimoga, it would be in the interest of the parties. Learned counsel appearing for the respondent submits that the suit is filed in the year 2022. 2022, and at present the suit is
For further cross of PW1, my lords.
for further cross-examination of PW1. It is submitted that they have been appearing before the court and pursuing the matter, and suddenly at the fag end, now at this stage, they have come up with this application, and the transfer on that ground, the transfer cannot be, the case cannot be transferred. Next para.
Your Lordship, one submission. Your Lordship, now it has come up at the stage of evidence. Every stage it is required to be taken instructions from the client, and they are unable to come to Bangalore, my lord. Being a school teacher.
Having heard the counsels on either side, peruse the material on record. In respect of the matrimonial proceedings, whenever the transfer petitions are filed, courts will always take into consideration the inconvenience that's being caused to the wife, and transfer petitions are accordingly ordered. When the party is seeking a transfer of cases from one court to the other court, they should come before the court at an appropriate time, or even in cases at a later stage, basing on the facts and circumstances of the case, the court would consider the same. The suit is filed in the year 2022. The MC is filed in the year 2021 by the husband at Bangalore. In respect of the MC that's filed, they have filed a transfer petition in the year 2023, and this court had transferred the petition. Now, till 2025, why they have not come up with a transfer petition? Now, no reasons are forthcoming. Now it is submitted that it is difficult for the wife to travel. Here, court is the important aspect is the judicial time of the court is very important, and they have wasted the judicial time of the court where the matter is pending, and court had spent substantial time on this case, and at this stage transferring the case from Bangalore to Shimoga cannot be transferred. Cannot be transferred. In that of the matter, this court finds no reasons to entertain this application. Accordingly, dismissed.
Cell number 4, M.R. Vijay Mathur for appellant, Ravish Bindi.
First for appellant.
Yes.
For second respondent.
For appellant, my lords.
What is this?
ECA, my lords.
Huh?
ECA.
Lord, please turn the para 3 of the judgment page.
Para?
Para 3 of the judgment. Owner admitted that he is paying the 3,000 rupees per month plus 50 rupees per bata. But it is his contention
So,
that
I
he was
think it
getting the
is the case that,
6,000 per month.
No, if this calculation is done,
Please,
is
ma'am.
it that case?
Yes,
Please.
my lords.
Other day,
Okay.
For 6,000 there is no any document.
But
It's only his say. But owner
they
admitted
don't have
that
any
he's paying only
document
3,000.
regarding, even they don't have any document to
why
show
should
that.
they have the document?
But
You are the one who is saying
yes,
that
my
this
lords,
is the
what
income.
he was
You should
working as
have-
cleaner as well as a
No,
helper.
if you
my lords.
want, last time I think you were there,
Yes,
we made the calculation. If that calculation is done, it would be the less than the amount. What is granted by the court?
But after,
So better will dismiss it that it has no grounds.
but he
Some-
having a personal permanent disability of 20 to 26%, my lords, for leg. And even girls are not coming forward to marry him, my lords, because of that.
How much is the amount granted? No, this is not that case.
1,26,000.
No. I think this is not the case. I think I was remembering the other one where it's a case of death.
No, it's not death.
Hello,
It's
this is
injury, my
injury
lords.
plea.
Let us see. Come to the calculation.
Para 20 of the judgment, please.
No. Read from there. The petitioner has contended that respondent was paying rupees 6,000 wages and 100 baht so and so contended is paying. How much the court had taken?
For 3,000 plus 150 per day, 4,000,
3,000 plus 50 rupees bata, my lord.
4,500 taken by the tribunal.
Court. So what was the, no, there is no evidence. What are the minimum wages as per the notification on the day?
As by minimum wages, actually, it's less than 3,000.
No, my lord, it's 8,000.
It comes to less than 3,000.
Where is it? You have the notification?
I don't have notification, please, madam.
Where is it? What is is there?
₹261 by that time.
Let's see.
Extended the year
Let's
of
see.
2013, please. Apart from it is admission given by the petition, the first respondent owner is paying 3,000 plus 150 rupees, 50 rupees per day pata. It comes to 4,500. Bata is not in a wages.
What is this? There's nothing in this.
My lord, after 2010, the minimum wages should be considered to 8,000, my lords. 8,000.
8,000 although
But they are not considered, my lord.
Yes, Ms. Shimoga. What is the minimum wages of the year 2013
13.
as per the notification?
EC.
EC Act.
2000?
13.
8,000. 8,000. ಅದು ಇದು ಅದು WCR.
Pass over, get that. Get it?
Please.
Yes.
Case number 5. Case number 5.
I have people applied in one case, respondent in another case.
Yes.
But one appeal.
Your appeal is also there.
Yes, my lords.
Your
I'm on the
appeal is on
point
what
of
ground?
negligence and as well as quantum.
Negligence and quantum. Let's see the negligence aspect first.
Yes, my lord. It's a case of death, my lords. It's a case that was crossing a national highway. When there are two sides of the road, there is a concrete wall. By jumping the concrete wall, my lord, she started walking towards the other side. The bus had, the accident had
They
taken.
contributed negligence or
Yes, ma'am,
no
contributed.
negligence at all from your
It's not
side?
a saying that it's not a case of negligence. It's a case of contributory negligence.
What did the court say?
Court says, my lords, that they proceeded on the police records and at para 16,
Let's read that.
paragraph number 16. Lordship permits, my lords, I'll read.
Please read.
Further, on perusal of exhibit P3 hand sketch, it appears that at the spot, the road was proceeding from western side to eastern side, and the bus was proceeding from western side to eastern side, and the accident has occurred at the edge of the northern side of the road. Considering the above facts, I am of the opinion that if at all RW1 has taken care and caution and drive the bus in a slow manner, then he would have avoided the accident. For the above reason, I am of the opinion that the defense of the respondent is not acceptable.
So let's see this. Yeah, give that exhibit P3. Exhibit P3. So with regard to the wall and other things, what is the evidence that is let in by you?
The spot sketch itself clearly says, my lords, on both sides there's a concrete wall, 4 feet
Oh,
wall.
was it your case?
Yes, my lord.
Where is that? Let's see. P3. Kannada. No, sketch I can understand.
But first I will demonstrate with the sketch and.
No. We'll see, like, in an appeal, all these grounds you cannot take for the first time. Let us look at their objections before the trial court. Yes, that you have taken that stand.
Yes.
Now we'll look at exhibit P3.
The bus was proceeding from Tumkur.
1 minute. Yes.
The bus was proceeding from Tumkur side to Bangalore side. Tumkur side is on western side.
Tumkur is on the left side.
Western side, this side.
Uh-huh.
Bangalore side is this side.
Hmm.
When the bus was proceeding from western side to eastern side, Lord, this is a 36 feet road, one side, another side 36 feet. Totally there is a median line on the
You are
middle.
on the left side of the road.
Yes, my lords.
And where is
The
this?
accident had taken place, my lords, 5 feet after the wall. Immediately after 5 feet from the wall.
Where are you finding that wall?
My lords, your lordship may get NH, my lords, in Kannada, my lords. NH Express Raste Tadagode means barrier. NH4 Express Tadagode. This is one side. And this side also, my lord, from the bottom towards Dakshina, that is southern side. NH Express
So
Raste
that, whatever
Tadagode.
that wall you are referring, that is the entire, on the entire wall.
Not entire.
Well, but it is somewhere here and the accident has happened much before, after that wall.
No, there is a wall, my lords. It clearly shows it's here Tadagode.
1 minute, look at this. That whatever that Tadagode, what you are referring to is here.
Yes,
Is
my
here.
lords. So the entire stretch is there is a Tadagode. Only it is mentioned at a particular stage that there is a Tadagode.
The cross-examination is that partially, Palpa Pramana, the partially barrier is, it's not that it is fully.
There is a spot master also.
No. That it is completely shown.
But in the
Cannot be advanced.
cross-examination, suggestion by them.
No, there is a sketch. They have made 2 lines in between. That's from beginning to the end. And in between they have written as so and so. Tadagode or whatever they have written.
But it is not their case that it is continuously
No, we
fully.
have stated. There is no
It is
zebra
speaking
cross
here.
also.
No,
Look at the sketch. Show.
in the
Can
cross-examination,
you
what
see
they
the
say.
sketch?
Suggestion is that,
No, you have the sketch with you.
I do not.
Look at the sketch. NH4. Nice, done. It is very clear from beginning to end. They've drawn 2 lines. In between, they have wrote that.
But my lord, in the cross-examination, suggestion put to PW1 is partially constructed. It is not. fully.
PW1 is who?
PW1 is the, my lord, on behalf of the
So
client.
that is not what
Cross-examination by the respondent. Cross-examination by the
we
respondent.
have to,
comes in.
you're relying, this is the sketch by you.
My lord, the suggestion, it is not their case that, my lord, it is fully, my lord, covered and by the wall, protected wall, and no one can cross the wall. That is not their case. Partially, Swalpa Pramana, the partially, partially there is a component. That's what their cross-examination.
Is there, probably what they meant is, maybe in between there is a place where one can come from that side. So, but still, you're not supposed to come from there.
My lord, if there is a way to come, my lord, the passage for the people to cross over, then it is permissible. And it is on the edge of the northern side. On the edge of the northern side, that is what the finding in
this
Paras.
accident has occurred immediately adjacent to that
36
wall.
feet road.
My lord, in National Highway, my lord, immediately after the wall, there won't be a road. There will be some gap between the wall and the road.
That's what it is there. They say that about, how
My
much
lord,
is the distance?
Each side of the,
36 feet, the total width of the road. The accident has taken place 5 feet from the wall.
my lord, each side of the carriageway is measuring about 36 feet. There was sufficient space for the bus to move. And when he has traveled, my lord, on the extreme left side, that
Yes.
is on the edge.
That's my proper.
We'll come to the calculation.
My lord, calculation so far as the income is concerned, my lord,
Which year is the accident?
My lord, the accident is the year
2014.
2014.
2000?
14.
How much the court had taken?
My lord, the
6,000.
Give that,
Tribunal has taken 6,000.
that year only. Court had taken,
Court has taken 6,000.
no, not
should have been 8,500. What is the age?
Age, my lord, 35 years, the tribunal has taken
38
it
years.
as
That is,
38. They are
that's my
claiming 38.
contention. Because in the inquest, it is specifically said 38 years. It can't be 35 years for the simple reason that the second petitioner, the son, was aged about 19 years. Therefore, it ought to have been 38, not 35.
My lord, my lord, in page number 14, judgment page number 14, the tribunal records, as per Aadhaar card, her age is shown as 32 years, but in the PM report, her age is shown as 35 years. Therefore, the tribunal has taken 35 years as the age of the deceased.
As per the Aadhaar card.
Not as per the Aadhaar card. As per the age shown in the PM
As per
report.
the Aadhaar card, how much?
32 years. 32 years. My lord,
Not be.
paragraph number 19.
And basing on what you're saying, she's 38.
Exhibit P5, my lords.
P5 is what?
P5 is, my lords, inquest.
PM report will have to be considered.
As per the
PM report exhibit P6,
it says,
it says 35 years.
we'll take 35.
My lords, one submission. Admittedly, my lord, the second petition is 19-year-old. It is their case, it's not my case. 19-year-old, kindly see the cost letter. Then if that is to be taken into
She's 16 years old.
16-year-old, 16 ವರ್ಷಕ್ಕೆ, it's very difficult to say that the child is born at the age of 16 years. Therefore, appropriate is 38 years. That's a wrong.
So how many are the dependents?
My lord, 2.
Lord, my submission
and
is
wife.
husband is not a dependent.
Hmm?
Husband and the son are parties before the court. My submission is
Given-
husband.
What is evidence letting? What is their case? What is your case with regard to the dependents?
Lords, in their evidence, they state that they are working in a garment factory.
She is working.
She was also working in garment factory. Husband is also working in a garment factory. She was earning 4,500 rupees. That's his statement. She was earning.
She's earning?
She was earning 6,000. She has stated so. But
Why should the court take more
No,
money?
no,
More amount?
it is not. The income of the PW1 is stated as 4,500 in the cross examination. The income of the deceased in the evidence, it is said that your lordship may kindly.
So in all the cases, wherever we are considering the wife as a dependent of the husband, we are not looking at whether the wife is working or not.
correct. I'm not
Vice
saying.
versa.
My lord, what
applies.
is stated in,
Vice versa, it should apply.
what is said in the evidence is she was earning rupees 300 per day.
So that will
That
come
comes to 9,000 per month. And future
So,
prospects
then,
not considered.
future prospects will come to 3,400.
And
It's
my lord,
11,900.
and conventional heads, my lord.
Huh?
Conventional heads,
Correct.
What is that?
conventional heads,
No, that will go, no, we have to, how much has to be deducted?
please.
Lord, interest was to be reduced. My lord, 9% is awarded. My lord, 6%
No, I
normally.
think calculation court has to do, you, both of you are jumping one after the other.
I just brought it to the notice of the court, my lord, since 9% was awarded, it ought.
That we will reduce.
Please.
No, thing is, on each head, we will do the calculation. 1/3 has to be deducted, 11,000. Is 3,966. It comes to, contribution would be 7,933
Correct.
into 12.
To 15.
35 is,
Lord,
16.
38 is 15, my lords.
35 is 16.
16.
It comes to 1 15 lakhs 23,200. Hmm, 15 lakhs 23,136. Conventional heads 44 into 2. $88,000, 36,000 funeral expenses, 10,000 legal expenses. Then contributory negligence, how much?
Lord, medical expenses is there.
How much was granted?
87,000. My lord, the bills are produced for 86,923, 87,000.
Quoted granted 87,000.
Yes.
Less 87,000. It comes to 17 lakhs 44,136.
50,000 interim
If the
compensation.
contributory negligence, we will take it from only 15 lakh 23,136. From that, the percentage of contributory negligence.
One more submission. 50,000 interim compensation has already been granted, given, that has been deducted by the tribunal. Therefore, that also has.
How much is given?
50,000.
It comes to 17 lakhs 94,000. Now, percentage of contributory negligence. How much?
Lords, my submission is, Lords, it is 50%, Lords. More than 50%, I leave it to the court.
We'll take 30% out of 15 lakh 23,136.
Please.
Lord, it could be reduced to 20% my submission. Because the accident has occurred on the edge of the northern side of the road.
It comes to 3 lakh 46,000, 3 lakhs 4,607.
30%.
27,
30%.
20%.
Let there be a mid path, my lords. Let there be 25%. That's a mediation.
Three lakh 80,784 minus 17 lakhs. 90. Instead of deducting, I have added 50,000. It comes to 16 lakhs 94,000, not 17 lakhs, 16 lakhs 94,000 minus 3 lakh 80,784. Then what is payable is 13 lakhs 13,352.
Please.
Agreed by the award passed in MBC number 3623 of 2014, dated 28th May 2015. Both the RTC as well as the insurance company, as well as the claimant are before this court. Claimant's appeal is MFA number 7099 of 2015, and the RTC appeal is, what is that case?
KSRTC.
KSRTC's appeal is MFA number 6263 of 2015. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the death of the deceased in the accident that took place on 10/7/2014. It is a case of the claimant that on 10/7/2014, at about 8:45 p.m., the deceased was standing on the side of the road near Anchepalia to cross the road. At the time, the driver of the KSRTC bus drove the same in a rash and negligent manner and dashed against the deceased, and she sustained injuries, and she was taken to the hospital, and later after 4 days she succumbed to the injuries. According to them, she's working as a coolie and earning 300 per day. It is a case of the insurance company that because of the contributory negligence on the part of the claimant, the accident has happened, and without looking at all this, the charge sheet is filed against the driver of the RTC bus. When it comes to the liability, the finding of the court is that with regard to the rash and negligent driving of the driver of the RTC bus, the finding of the court that the police have registered a case against the driver of the bus, and after completing the investigation, they have filed the charge sheet. And further, on perusal of Exhibit P3 hand sketch, it appears that at the spot, road was proceeding from western side to eastern side, and the bus was proceeding from western side to eastern, and the accident has occurred at the edge of the northern side of the road. Considering the fact, the court is of the opinion that if at all RW1 has taken care and caution and drive the bus in a slow manner, he could have avoided the accident, and held that the accident has happened because of the negligence of the driver, and held that the RTC is liable to pay the compensation, and compensation full stop. The tribunal had considered the income at what, 6,000,
6,000.
and one-third was deducted. One-third was deducted by applying the multiplier of 16, considering the age at 35, and granted compensation of an amount of rupees 9,30,000. Learned counsel appearing for the insurance company, for the RTC, KSRTC, submits that there is a wall alongside the road. It's a wall alongside the road, and the deceased has crossed that wall, and she came onto the road, and the accident has happened. It is a case of it is a submission of the learned counsel that the accident has happened because of the negligence on the part of the deceased. Further, it is submitted that the court had considered the husband and the son as dependents. Husband is not a dependent on the wife. It is also stated that the multiplier, that is the age, has to be considered as 38.
Please.
As per the
Inquest report, Exhibit
as per
P5,
the inquest report, and the multiplier would be
50,
50.
1-5.
Multiplier has to be 15, but not 16. It is submitted that the compensation that is awarded by the tribunal is on the higher side. Learned counsel appearing for the claimant submits that court had rightly considered with regard to the negligence of the driver, and when it comes to the compensation, court ought to have taken the income at 9,000. Instead of that, the court had taken it at 6,000. Future prospects were not considered. It is submitted that as per the postmortem report, the age of the deceased is 35 years, and court had rightly taken the 16 as the multiplier. He submits that even on the conventional heads also, the amount that is granted by the tribunal is is not appropriate and needs to be enhanced. Next part, having heard so and so. The first, coming to the aspect of the contributory negligence, this court has perused Exhibit P3, the sketch, and the sketch clearly shows that the bus was on the left side of the road, and there is a wall alongside the national highway, and the accident had happened. The width of the road is 36 feet.
36.
And it happened
From 5 feet.
from the wall. It is 5 feet
feet.
from the wall. The accident has happened. Looking at Exhibit P3, this court is of the view that there is negligence on the part of the deceased, and the tribunal had failed to consider the same. In view of the same, the negligence, the contributory negligence, is apportioned at 25% on the deceased and 75% on the driver of the RTC bus. Then coming to the compensation, this court is not able to appreciate the submission of the learned counsel that the wife and the husband and the son are not the dependents on the deceased. Whenever an application is, whenever in a case of death of the husband, the court is never considering the fact whether the wife is working or not. In all those cases, court is considering the wife and the children as the dependents, and the same analogy will apply even in case of a, in case of a death of a wife also. Hence, this court is considering both the wife and the son or as the dependents. 1/3 has to be deducted. Then coming to the income, according to her, she's working as a coolie and earning 300, and per month it is 9,000. No doubt there is no evidence in that regard. Hence, as the accident has taken place in the year 2014, this court is taking the income at 8,500. The court ought to have granted 40% future prospects. It would come to 3,400, that is 11,900. As there are two dependents, 1/3 has to be deducted towards the personal expenses. 1/3 is 3,966. Then the contribution to the family would be, say, 7,933 into 12 into 16. The loss of dependency would come to 15,23,136. Towards the conventional heads under the head of consortium were 2 into 44, 88,000. Funeral expenses, 36,000. In the light of the law laid down in so and so, 10,000 towards the legal expenses. The trial court has already awarded 87,000 towards the medical expenses and there are no reasons to interfere with the same. It is submitted that already the RTC has paid the compensation. What is it called?
50,000, interim compensation.
Interim compensation of 50,000 from the total amount of 17,44,136. If that 50,000 is deducted, the compensation would come to 16,94,136. Then as this court has fixed the contributory negligence at 25% on the deceased, the same needs to be deducted from the loss of dependency. That is 15,23,136. Then it comes to 3,80,784. If the same is deducted from 16,94,136, what is payable by the respondent, by the appellant corporation to the claimant is 13,13,352. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 9,30,000 to 13,13,352. The appeal of the RTC is also partly allowed by reducing the rate of interest from 9% to 6%. Then in his contentions also about that you add. Yes. We'll see. Yes, next.
Chair number 6.
This matter may kindly refer to the Adalat Lordship.
Millard, quantum is challenged, Millard. By the KSRTC, Millard. It is a lesser, Millard, it may be dismissed.
You appear for the claimant.
I apply for the case artist. It could be settled, it could be posted for Adalat. If not, it could be posted on Monday Lordship Senior.
So we will do if it is agreeable to them or not, we can, why to waste
Because
time?
with respect to calculation, Senior is out of town.
No,
so,
I'll do the calculation.
But Senior
No,
should
even if
agree.
your senior is there, then also the court will do.
Lordship, it could
Please
be
come.
posted on Monday
Please come to-
Lordship.
We'll see. Don't
yes.
worry, we'll not pass any orders which is adverse to your client without giving an opportunity.
Millard, extent of is of the year 2013, Millard.
2013.
13.
How much is taken income?
Only 4,000, Millard, 8,000 ought to have taken.
No, this is appeal by the RTC.
Yes, sir.
KSRTC
Yes.
on the quantum law.
Yes, yes. So 2013 court no, their appeal, why you want all this?
Therefore, Millard said it has to be dismissed.
Oh, 2013, how much the court had taken?
4,000 only.
4,000.
Disability at 25%.
Disability?
25%.
What is the evidence of the doctor?
Millard, doctor has said Millard has got mental disability, he can't walk regularly, Millard, and he was falling down. In view of
Let
Millard
us see
is
that.
Millard, issue number 2, Millard. Para number 13, Millard. According to Exhibit P13 wound certificate and the date of the accident, the age of 45 years, then Millard. Sorry, Millard. Before that, Millard. Millard, para number, issue number 9.
In page
According to the doctor, it is 25% disability.
25% to
Court has
whole
also
body,
taken.
to whole body,
Court has also taken the same.
taken the same.
Lysis matter. Lysis matter as part heard on Tuesday.
Delete from caption.
Tuesday.
Tuesday.
Yes.
22.
Heard the counsels in part. Yes, 7.
My lord, the counsel.
Delete from caption.
Or delete from caption dismissal.
Number 7.
My lord, the counsel for the petitioner, Mr. Basavaraju, he is paralyzed, my lord, I'm informed. I'm proxy counsel only.
Lysis matter, delete from the caption for dismissal. Lysis matter after vacation.
Number 8. Pankajappa, MG.
Yes.
In which time method, proper
Why?
steps to be a respondent number 1, my lord, owner of the vehicle.
Since
Paper
3 times it
publication.
is happening.
Paper publication is.
Finally, time is granted till 4th of June to take the steps, or else the appeal shall stand dismissed in respect of the respondent number 1, and no further time will be granted.
Yes.
Cell number
Yes.
9. For orders matter, cell number 9. Jay Shri.
Yes, appeal for petitioners.
Hmm?
Necessary for petitioner matters.
Non-furnishing of cover acknowledgement. to
Matters,
issue notice
necessary
to
steps will be taken.
7 and
For
8.
space time.
Give that file. We are a CP of 2023. It's coming up for orders now.
Yes.
What is this petition?
First to transfer this case from city civil court to Anekal. Because
That? Give the file. This is filed in the year 2023.
23.
Uh,
Yes, matters.
So 23 to 20, this is matter next week. By that time, the petition shall place before the court the proceedings of the suit, that is OS number. Which case you are seeking transfer of?
2952 of 2018.
The proceedings of the case which the petition is seeking transfer.
25-4.
Yes, next.
25-4. Cell number 10. Adisha N.
No representation for dismissal.
21.
Yes.
Cell number 11. Cell number
Same.
11.
Same. Next.
Cell number 12.
Petitioner in this case, pray for a week's time, my lord. We will take steps for a week's time, I can.
Give that.
Insufficient address and Shara.
Take out notice on the council. The petition shall take out hand summons on the council appearing for the respondent before the trial court. And you have a stay in this.
My lords,
You have a stay.
yeah, my lords, kindly extend the interim order.
Shall and take hand summons and file a memo to that effect by 24th of June, or else if it is filed, list it on 25th, or else the stay granted by this court stands vacated. Look at it about the stay, whether it is extended or not. Yes, next.
Interim stay may kindly be extended.
If it is there, it will be extended. Yes.
Cell number 13. Hari Prasad.
For the petitioner,
What is
Your
this
Worship.
memo of hand summons to
Your Worship, on
RPID?
the same day only, we have served the hand summons through the RPID and also through the, by hand, Your Worship.
Where is the
At the
hand
same
summons?
time,
What is
we
hand
have,
summons
we have
by
the acknowledgement,
RPID?
Your Worship. From the other side, we have the acknowledgement here.
No, if it is hand summons by RPID, why it is hand summons?
No, for our reference, Your Worship.
You that.
Along with that, Your Worship, we have shared the petition copy through the WhatsApp in front of them only, but petition copy. Yes, sir. Shared the petition copy with the WhatsApp.
Where is the memo? Just find the so and so. Where is it? No memo. Where is the memo?
Worship, on 27/2, we have filed in counter, Your Worship. This is the acknowledgement for office.
Where is that? To whom they are served?
Yeah,
You have to write the details to whom you are served.
other side respondent, Your Worship, in
Who is
trial
the
court,
other side?
who are appearing in the trial court. Rakshit Gowda, name.
The petitioner shall file a memo by Tuesday, a fresh memo stating that to whom they have served, mentioning the advocate's name.
Advocate's name.
Yes, next.
Cell number 14,
List after service of notice,
cell number 15,
same 15.
Petitioner, we served this notice to the council. He refused to receive.
Hmm.
And he says, you do whatever you want. In Kannada is written, we have submitted already with a memo in the last occasion. Now respondent also, we have sent a notice through the court, which is served also, I think. He has appeared with,
Where is that?
but it says await for service. He has received it. Yesterday, he made a mention before the trial court, he has received the notice. But
You
he
have
has not present.
this?
Huh?
You have a stay in this?
Oh, yeah, till as on date, today, 17th, you
Oh,
have given the
like I
stay.
think I was reluctant to grant.
My lord,
stay in
yes,
this
my
now.
lord. And that,
The stay granted earlier is extended until further orders.
yes,
It is submitted that the respondent counsel has refused to receive the notice and yes,
respondent also was present at that time
and
before the
respondent
council.
also is present, and it is stated within the council that he has gone to the extent of saying whatever you want to do, you can do. Whatever the petitioner want to do, he can do, but he will not take the notice.
Shall I read it out, what they have written in Kannada, madam?
In considering the submission of the land council, the interim order that is granted is extended until further orders.
Much obliged.
cell number 16, AM Venkatesh. For appellant, AYN Gupta.
Have you served the copies?
No, my lord, it's not served.
You should have done it before.
Day before yesterday.
Pass over. Next.
Kindly called on Monday, my lord. I had some personal inconvenience.
Problem is court will have so much of inconvenience to adjourn the matters. Everything, the list is running into.
Now my relative is Monday.
Yes, give some other day. Next.
23.
Have you given him prior? He would have argued it. Yes, next. 17.
Cell number 17, cell number 17, Sita Ramarao, BC.
May I request my lords to dispense with production of translated copies.
This is matter after vacation. Yes.
Cell number 18,
Lord, I am for appellant, my lord. I am for the production of
Yes,
these.
Mr. Shivanagoda, these translated
Next.
copies are required.
Not sell the petition is dismissed. That is the reason it is. Your lordship has directed him to
File.
Next
claim
week,
petition
will-
dismissed.
This is matter after vacation. Next.
cell number 19,
For the appellant, madam.
Who is R2?
Abhijit MM,
For the appellant, madam, press week.
Who is R2?
Gil,
R2 is the owner of a vehicle, madam.
What are you doing without paying the process? Finally, a week's time is granted for paying the process in respect of respondent number 2, or else the appeal should stand dismissed against the respondent. Next.
cell number
Please, ma'am.
20, Mohammed Tahir, for appellant, Veerabhadra Swamy,
Without accommodation may be given to,
Week's time, R4, same order.
please, Lord.
cell number 21, Shankar Gowda G,
Yes,
Shankar Gaud G,
dismissal for tomorrow, like whatever next date. Give a date.
21/4.
Yes,
Cell number 22, Gopal LT,
dismissal.
23/4.
Yes,
Cell number 23, SM Anish,
Appellant, the respondent number 3 has been died, my lord. Respondent number 3 has been died. 1 and 2 are the legal yes. I filed in memo. And R4 copy has
where
been
is
served.
that memo? The memo, land counsel appearing for the respondent, number 3 has filed a memo
The appellant is
stating that,
deported.
stating that R3 is no more.
R3 is now.
A memo is filed by the land counsel for the appellant. Where is that memo?
Memo dated 3rd April.
There are two memos. a memo is filed dated 3/4/2025 stating that the respondent number 3 died on 23/9/2019 and all the legal Yes. Hostile. Yes.
Copy to R4 has been
But,
served.
like post-mortem profiling.
Yeah, LCR.
Huh?
LCR.
Call for the TCR. Yes, next.
Cell number 24, Nagaraja K.
Malad, I yet for the appellate case RTC. I am ready, Malad. Accident.
Ganapati.
Yes, I am for respondent and.
2019 matters. Anyhow, it's a batch will complete.
Please.
Hmm. How many matters are there?
Malad,
14.
8 matters.
7
8 matters.
appeal and 7 cross appeals.
Hmm. Your crop is where?
Yes, ma'am.
How many you have filed?
7.
You have filed 7? 7 appeals, 7 crops. Hmm.
Yes.
Huh. Now, before we go, MFA 1613, what is the crop? You have the data?
Yes,
Here.
ma'am. Crop 68/19.
68/19. 68 and of 19. Then in respect of, no, it is, there is another, then in respect of MFA 1614?
Crop number 69/19.
1615?
Crop number 70/19.
Next 1616?
Crop number 71/19.
Yes, no, you said.
71/19.
That's what you said now. MFA 1615, I said.
70.
70.
70.
It is 71. 1617?
Crop number 72/19.
Oh, it is like continuation numbers. 72, then it is 73.
73/19.
74. Yes. Do that.
The accident is between.
Now we are taking the first one. 1613. Yes.
Like the accident is between the case.
This is arising out of MFA 1613 arising out of
MVC number.
MVC number 397.
Bar 14.
Bar 14.
397. Now let's go to 397. You are
Yes,
on what
yes.
ground?
Both on the ground of negligence, quantum, I am not urging. Because
Negligence is on the contributory negligence.
yes, madam.
Where is it? Come to that issue. We'll read that.
Yes, madam. Issue is typed page number 15, para number 11. I have gone through the entire materials available.
1 minute. 1 minute.
Yes, madam.
Please read.
But I have gone through the entire materials available on record. According to the petitioners, on 27/1/2013, at about 11 a.m., they were proceeding the Maruti Estilo car, and during that time, the respondent number 1, being the driver of the KSRTC bus, drove the same in a rash and negligent manner and dashed against Maruti Estilo car and caused this accident. And due to this accident, all the petitioners have sustained grievous injuries. The contention of the respondent number 1 and 2 is that the accident occurred only due to the rash and negligent driving of the car by its driver. Since the petitioners have approached this court, they have to prove the allegations made in their petition. In their chief examination, P1, PW1 to PW7 reiterated and reaffirmed their contention taken in their respective petitions. They are cross-examined at length by the learned counsel for the response, but nothing is elicited in the cross-examination to disbelieve their evidence. Their evidence is reliable and believable because all the family members were moving in a car. Under such circumstances, it is not possible to hold that the driver of the car has taken the risk of driving the car in a rash and negligent manner. P1 notice, P2 FIR, P3 complaint, P4 spot marcher, P6 IMV report, P7 charge sheet. submitted before the concerned court. On going through all these documents, it reveals that immediately after the accident, injured were admitted to the hospital and complaint was filed before the police station as per Exhibit P3. After investigation, Iowa has filed charge sheet against the R1 for the offences punishable under Section 279, 337, 330. On going through the Exhibit P4 spot merger, it reveals that the accident spot is a curve road and width of the tar road is 16 feet, and towards southern side of the spot there is 9 feet width, and on the northern side there is only 2 feet width. Well, at this stage I will stop for a moment and submit that it is quite opposite side. On the opposite side means it seems the tribunal has confused. And that's why, my lord, I have filed a sketch.
Show the sketch.
Yes. My lord, along with memo, I have filed sketch.
Yes, I've seen.
Yes, ma'am. But your lordship, my technically, the bus was proceeding from west to east. Madam, number 1 is there, madam. Number 1. Serial number 1. 1 is there in the sketch. Spot of accident. The bus was proceeding from western side.
This here is not there.
Pardon? Only on the basis of the merger.
Exhibit. This is marked as sketches.
Sketch not marked, my lord, sketch not produced. Therefore, I have this sketch was produced before the magistrate court in criminal case. Just only for the purpose.
Oh, just like that you have placed the sketch before the court.
My lord, only for the purpose of understanding.
That is what I'm saying. Why would the court look at the sketch only for the purpose, just like that in an appeal?
But my lord, just to understand the contents of the
No,
merger.
not necessary to understand a document which is not part of the record.
My lord,
If some document has to come on record, it has to come in its own way.
My lord, your lordship may kindly see in the exhibit. I have produced the judgment copy passed by
the court
criminal
records the finding that he was acquitted in the criminal case only on the ground that no eyewitnesses have identified him, not on the fact that whether there is any negligence or not. That's a finding of the court.
My lord, I have produced exhibit R1 to R3 photos.
We
and
have.
Exhibit R1 to R3 photos.
Yes.
R4 is the copy of the judgment.
Hmm.
Now, my lord, I take your lordship's kind attention to exhibit R4.
What is exhibit R4?
Exhibit R4, that is the judgment passed by the trial court, magistrate court.
It's P37. R, it is referring to R. Yes. Yes.
Well, kindly come to para number 24, page 16 of the judgment in CC number 1549 of 2013.
Yes.
Well, para 24, as could be seen in exhibit P12, spot sketch prepared by investigating officer, it is seen that the accident occurred in a road curve and the KSRTC bus standing in the extreme left side of the road. In spite of this fact is not explained by the prosecution as to how. But as per exhibit P12 spot sketch, it is clear that the bus was on the left side of the road.
No, this in the criminal case, you are the prosecution witnesses.
I am the accused.
I'm not, I.
What is the name of the claimants?
Claimant name.
Pratibha Naidu, Dhanalakshmi,
Lakshmi, Dhanapal Naidu, Prakash.
they are the claimants.
Claimants.
I think claimants are the witnesses. The criminal case.
In that case, I think they are not examined.
What are the names of these claimants? Please tell the court.
Claimants, names of the claimants are Malad Velocipet, and this is last page of the Dhanalakshmi.
Yes, they are the ones. You are the ones.
D. Prakash
Before
D.
the magistrate court.
And others are minors.
Dhanalakshmi, Pratima.
Bhumika is age.
Prakash.
Dhanapal
All of
Naidu.
them are the witnesses before the criminal court. Criminal court gives a finding saying that the accident has there is no negligence on the part of the driver.
Now, Malad Velocipet, kindly see the photos.
Please refer to the records.
Please.
Yes.
Give him the record. In that case, that was not questioned. You could have always, there could have been an appeal against the acquittal. And what is other material to show that there is negligence on the part of the bus? That is relevant. Look at it, we'll take in the afternoon. Yes, next.
Now, Malad, I take your lordship's kind attention.
No. Please wait, we'll take up in the afternoon. Let him go through the record.
Pass over.
Yes, next.
Cell number 25.
Please.
Yes.
Cell number 25. R. Lakshmana.
This matter came up. First, R1 is the owner of the vehicle.
Insured.
No.
Liability has been fixed on the insurance company.
Insurance company. Though the matter listed yesterday, there was no representation. Today also there is no representation. This is matter for dismissal.
23.
Yes. Yes. This matter also. 26.
26.
Manjunath. This also for dismissal.
23.
No representation. Yes. Next 27.
Number 27. Suresh Kumar Acharya.
R3, I have to furnish a fresh address 1 week time.
To issue notice to R2. Who is R2?
Who is he's also one of the claimant, one of the party.
But for furnishing the for taking step.
Only against
he
R2.
says the needful will be done in
1 week.
In 1 week. Yes, next.
Interim order.
Number 28.
Look at it. Interim order is extended.
28.
For the plaintiff.
28, my lord. I am
Filed 2 applications, my lord, for further additional documents.
My lord, on the last occasion, my lord, the council was absent. They were, my lord, required to serve me the copies of the application, which is not done.
I've already served, I'll serve one more copy, my lord.
Then what to do now?
It is not served, my lord. Kodi.
Without serving on them, we can't hear the matter.
Please.
Yes.
I'll have on 21st, my lord.
Yes.
24th.
Whatever next day, because already flagged, there are several matters. Then counsel the respondent submits that the papers are not served, applications are not served on him. Then counsel the petitioner submits that he will be serving it today.
Please.
This is on so and so. Next.
Please.
Cell number 23. Cell number 29.
For the appellants, my lord. In this, my lord, appellant number 1, 7 and 8 and respondent number 7 have died. Lord, insofar as appellant number 1 is...
Notice is ordered in this.
No, my lord.
Appellant died.
Lord, three appellants and 1 respondent have died.
No, who are the appellants who have died?
Lord, appellant number 1.
1.
Their LR is already on record as appellant number 2.
Where is the memo in that regard? Look at it and show me that memo.
I'll file a memo, my lord.
I think this has come up on the last occasion.
Yes, my lord. I will file a memo.
Why are we wasting time on this like that?
Lord, on the
This is
last
matter
occasion-
after vacation. Yes, next.
Number 29. 30.
Yes.
Number 30. VB Sidramaya.
Yes.
Mediation.
No, step 1 is over in the morning. Objection. No, step 2. Do it before the trial court. We will not decide all that here. 2024 matter. From where to where?
From Bangalore to Puledgudda, my lord. It's Bagalkot district.
Bangalore to?
Puledgudda, my lord. Bagalkot district.
How much is the distance?
537 kilometers, my lord.
The
Lordship, refer to mediation, lordship.
There you go to the court, that there is the mediation. Is there any scope for settlement?
I don't have any instruction, my lord.
The present petition is filed seeking transfer of MC number 4. Monday. You want to file objections. Finally, list this matter on the Wednesday. If the objections are not filed by that time, the matter will be heard on the merits of it. Yes, next.
Bill number 31, Chandana Tariga for petitioner.
This is the matter which.
Yes.
My lord, the transfer is sought from Bangalore court to Bangalore court.
Is it a matrimonial matter?
It's no, custody of the child.
Custody of the
Custody of the child.
So, where is the child?
Child is at Bangalore. Mother is at Bangalore. She is working at Bangalore. And the visitation right of the child is given to the
father at Bangalore.
Now, the objection is filed by the respondent saying that in the MFA, my lord, against the.
No.
Yes.
You have filed this.
I have filed this petition.
Taking transfer from where to where?
Bangalore to Bangalore.
Earlier, the minor was in Bangalore. Now he is in Bangalore.
Yes. 2022 onwards.
He was in Bangalore.
Bangalore. He is in Bangalore. Yes. Earlier
in
he
Bangalore.
was in Bangalore.
He is in Bangalore.
He is in Bangalore.
Yes.
2024 they filed a.
So on that ground, you want the GNWC to be transferred to Bangalore.
Yes. The objection raised by the other side is.
Let us hear.
Please.
Yes.
Please.
My lord, so far as my submission, my lord, the child is not residing in Bangalore.
Why are you granted visitation rights in Bangalore?
My lord, what happens, my lord, when I'm exercising my visitation right, apparently child tells that he comes all the way from Bangalore to Bangalore, exercise, and thereafter goes back to Bangalore. My lord, in the petition or in any of the pleadings.
To bring this notice to the notice of the court which has granted you visitation.
Beg your.
Did you bring this to the notice of the court which has granted you visitation, saying that boy is in Bangalore, but whenever the visitation is there, he's coming to Bangalore?
I brought this to the notice of the court, my
What
lord.
did the court do?
At that point of time, my lord, they said that their submission was mother was working here, and therefore the court said that you come and exercise visitation
we
rights.
have to, for all practical purposes, we have to consider that the boy and the mother are residing in Bangalore.
My lord, there is no document produced by them, whether the school living certificate.
What is she doing here?
Absolutely no document produced.
Yes, madam.
What is she doing?
She is working in a mercantile bank.
So where is the document in such support?
Yes, madam. Annexure 3.
Annexure 3.
3 to the rejoinder. Page 11. Rejoinder.
In the to the main
Rejoinder was filed yesterday.
Yes, it is here.
Yes.
You filed the orders in other matters.
That is at the petition itself. Yesterday it was filed.
Dated 8.
Dated 16/4/2025.
Yes.
Yes. Now would your lordship kindly go to annexure 3, page 11. It says, and this is from Marshak Global Services Private Limited, to whomsoever it may concern. It is dated 15/4/2025. A certificate.
When did you file the JNWC in Bangalore?
No, he filed JNWC in Bangalore.
When?
That was in 2024 October.
Yes.
My lord, these.
Then this is Rainbow School.
Yeah, my lord.
International school.
No, this is the school. Now, child is with her at Bangalore. Now,
I understood
yes,
that.
only that.
Yes.
And my lord, one more thing I need to bring. Kindly see annexure 1, page 9. It is to his knowledge that I am the petitioner and the child are at Bangalore. Kindly, this is the notice issued, summons issued from the court at Bangalore. In that, he gives the address. Kindly
Yes,
see,
Mr. Counsel.
address of Bangalore he gives, and I have received that and filed the postal acknowledgement.
Yes.
My lord, my statement of objection may kindly be perused, my lord. Two documents, my lord, I produced. 2023, my lord, they filed a divorce petition, my lord. I filed a petition for restitution of conjugal rights. My petition was allowed. Their petition is dismissed. Against which they filed an MFA before this honorable court, my lord. The MFA number, my lord, they give Mangalore address. Thereafter, my lord, in 2024, they filed one more application, my lord, under section 24 and 26. In that also, my lord, that is in 2024. In that also, my lord, they mention the address of Mangalore. The address was mentioned at door number so and so, Boluru Gadde House, near Janardana Temple, Mangalore.
Talking about the changed circumstances, that too in a GNWC matter.
Yeah.
Where the ward is.
Yes, my lord, I understand where the watch, but to show that, my lord, what is residing here.
They have filed the school.
That's only a summer camp, my lord. That's only a summer camp for 10 days. There is no school. That is only a summer camp. It's
Where
just.
is that? It is a summer camp.
It's summer camp. If they produce any admission thing, my lord, I understand. It is summer camp. There is absolutely no.
Who stopped you from filing the school receipt?
My lord, the boy is 4 years old. They are not admitted. There is a government restriction that certain age, below the certain age, they are not.
What is the school going age in Bangalore?
Now today's the newspaper says it will
Not
be.
today's newspaper, generally.
Generally, it is 5 years.
LKG
yes,
UKG will start before that.
And my lord,
You deny that?
LKG will start, my lord, when they're 3.5 years of age, my lord. LKG,
no,
then
she could not.
UKG,
she
my
could
lord.
not do it. And his own statement. Kindly see this. Annexure.
5 years is for first class.
No,
six, first class.
6.
6 years.
6 years.
So the PP1, PP2 will be there.
Yes,
Pre-primary 1 and 2.
Yes,
Pre-primary would be after 3 years.
My lord, the school, the child is not admitted to the school.
What we'll do is,
Yes.
you let your client file an affidavit before the court.
Yes.
Stating that I am residing in so-and-so address from so-and-so date.
I have stated so, my lord.
No, is it an affidavit?
Yes. No, this affidavit, it is accompanied by an affidavit. Kindly see this.
That is a work address, my lord.
My lord,
That's not
I'll
work
make.
address.
Why this
He's
is
working from home.
the paragraph.
No.
Paragraph 7. The son of the petitioner is now aged 4 years 3 months. He is with the petitioner at Bangalore. The petitioner quite often requests her mother to come and stay with her at Bangalore to look after her. Even for that, he had objection. Now, paragraph 5 may kindly be seen. Petitioner is working with the Mashreq Global Services, 3rd floor, Prestige, Shantiniketan, so and so. The respondent has furnished the above address of the.
I've seen, Mr. Ariga. What you can do is,
Yes.
a precise affidavit as stated by the court you file, will
Yes.
consider it.
That she is.
It is the contention of the learned counsel for the petitioner that she is residing in Bangalore. Boy is yet to be joined in the school, but is going to a summer camp.
Yes.
According to the learned counsel for the respondent, she is working from home from Bangalore only to harass the husband. This application is filed. Next para. The petitioner wife shall file an affidavit before this court stating giving the particulars from when she is residing in Bangalore, in which place, in which company she is working, and whether she is working from home, Bangalore, or from the office in Bangalore, and whether the boy is with her in Bangalore or he is residing with her parents at Bangalore. With a specific statement, an affidavit shall be filed before this court by
tomorrow, my lord. I shall, because she is in Bangalore.
Tomorrow is a holiday, Monday. I'll post this. No, I'll post it on Tuesday. List this matter on Wednesday.
My lord,
Monday, you shall file it by Monday and give the copy of the the copy to the learned counsel for the respondent. If any objections he has, he shall, what objections you can have now to
The
that?
child is here, my
So
lord,
we'll
I will not have
we'll
any
say,
objection.
file it on Monday, we'll take up on Monday.
My lord, I have no objection to this at all. In this rejoinder, which is accompanied by an affidavit.
No, you
she-
specifically state this.
Yes,
I want an affidavit.
yes.
Affidavit
Yes.
and you file it on Monday, we will hear it on Tuesday. List the matter on Tuesday.
Saturday file ಮಾಡಿದ್ರೆ, sorry, Saturday I'll file it.
And
I'll
then,
serve it on him tomorrow itself.
Yes, Monday.
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 Yes.
Next.
My lord, can I take the copy of this order?
Yes, today by evening.
Yes.
Type it.
Cell number 32.
My lord, interim order may kindly be used.
Yes.
Please.
Cell number 32.
I am for the-
Kaushik.
I am for the respondent, my
I'm
lord.
appearing for the petitioner, Your Honor. Your
My lord,
Lordship.
may I submit this, my lord, because I am yet to receive the entire petition. So, my lord, there is.
I have already served a copy through.
Anyhow, you
WhatsApp
have a
yesterday.
stay.
Yes, yes.
Everybody has lot of urgency in
Yes.
spite of a stay.
My
List
lord,
this matter
no,
after
no.
vacation for objections of the respondent.
My lord, I have one submission before that, my lord. There is a strong possibility of reconciliation in this marriage, man. So that's the reason the mediation in which has taken place in Ranebennur court, which is not appropriate, it has happened in the corridor of the court. What my request is, but at my cost, if the mediation, if this matter can be referred to Bangalore Mediation Center, there is one strong
client is
possibility
ready
that
for
two kids
There is a difficulty, my lord.
Yes, just leave it for objections. List this matter after vacation, interim order earlier granted is extended. Next.
Cell number
Okay.
33. Cell number 33.
Seeking for a transfer of matrimonial dispute from Bangalore to Chikmagalur, my lord. The distance is 250 kilometers.
Why
Petition,
is wife for
I'm for the wife, my lord.
No memo is there, why I'm thinking, why it's a memo. MC of which year?
But 2025, my lord, it was filed 2 months
The
back.
present petition is filed seeking transfer of MC number 1918 of 2025, pending on the file the principal judge family court to the family court at Bangalore. The distance between both the places is
250 kilometers.
250 kilometers. Any children?
Two children, my lord, they are staying with the
And the wife has to
father.
take care of the.
The children are staying with the father in Bangalore, my lord.
Huh?
The children are with the respondent in Bangalore.
Then you want the matter to be transferred.
The difficulty, my lord, it's a divorce proceedings and she's unemployed, my lord.
Notice.
My lord, the matter is coming on 24th, my lord.
Let it
It's
come.
for objections.
Will not grant, will not grant. Notice.
My lord, any
Petitioner
date
hand
before-
summons to the counsel for the respondent and file a memo to that effect. Once the memo is filed, this is the matter.
My lord, any date before 24th, my lord, because 24th is coming up for objections. If I don't file objections, it will be taken as
Let her
not filed, my
file,
lord.
let her file. Yes,
Cell number 34. This is Shivanya Gowda.
where is Chandrasekhar HP?
Chandrasekhar.
On what ground you are before the court?
Insurance company appeal on the ground of liability as well as the quantum of compensation. The point is, my lord, on 11/4.
It's a case of death or
Injury case.
how much is granted?
1,47,795.
1 lakh?
1,47,795.
795. First of all, we'll look at the liability aspect.
Please, well, what has happened, madam, on 11/4/2007,
Liability means you're saying that on.
as per the hospital record, at the 9:30 AM, he has admitted to the hospital, stating that he has sustained injury. After that, my lord, he lodged the complaint stating that 11/4/2007 at 5:30 PM, I have sustained injury in the course of employment.
It's in the WC Act, this is.
Please. At 9:30, I have placed the MLC record before the court.
As per the medical reports, how he has sustained injuries?
He has sustained injury,
In employment only.
not employment, man. He has sustained injury. That's what he says. That, man.
No, it will say how he has sustained.
That was not mentioned in this, but may I pass it on? This is marked document. This is the only first one. First entry, 9:30, he has admitted to the hospital. AM,
Goregowda.
please.
So it is your contention that it is not during the course
He
of
is not
employment.
involved in the accident.
No representation. This matter as part heard for the respondent, counsel for the appellant, heard in part. Yes, next. Someday wherever there is less matters. Yes.
Serial number 35. Nagaraj Hegde,
Translated copy
appellant.
of the judgment.
What is that?
Translated copy of the
Who
judgment.
appears for the respondent?
Respondent S. S.
They are not
Nirmala
there.
for R2.
Respondent not there. After vacation? It's a case of death.
It's a case of injury.
After vacation, at the request, no representation for the respondent, counsel for the appellant is present.
Translated copy may be taken on record. Translated copy
Yes,
may be taken on
counsel has filed the translated copy. 36, 37 after vacation. These are they are in admission. They are coming up for admission.
Admission.
Admit post for final hearing. District is directed to call for the RCR. 21 also. 30 till 39. Admit post for final hearing. Call for the records.
38.
38 is also admitted.
Admit for final hearing TCR.
I'm obliged.
40.
Serial number 40. Gopal Krishna N.
38 may be referred to Lok Adalat.
Which one?
38.
Very well, both the counsel submit that the matter may be referred to the Lok Adalat. Refer it. The registry is directed to place.
Now itself you will negotiate. If it is agreed.
I am ready. I'll.
Then you negotiate, but then we'll give a date. Once you report, just keep it. You just negotiate on that. If it's happening, we'll say that on all the matters are coming up on Monday or Tuesday. Tuesday we'll give a date. Yes.
Very well, I'm obliged. 39 also, ma'am.
9?
39.
39
Connected
also. That
matter
also
is-
pass over, keep it pass over.
Connected matter has already been settled before the Lok Adalat. Maybe referred to Lok Adalat.
39. If they are there, you can talk to them. We'll keep it till evening. If something works out, you can. 39 and 38 pass over. Yes, next.
Serial number 40.
Appellants, paper appellant Mailand. Climate,
Where is Mr. Sridhar?
I think he's not well, I am told. He's not well, I am told that.
This is matter after vacation. Yes.
41.
41 after vacation. 42
42.
after vacation. Yes, call this the next list.
Leave of the court.
Uh-huh.
The leave of the court one submission, serial number 11, my lords. I was held up in
What has happened to that?
that it was come on office objection, my lords.
Uh.
I've served the notice on 3 occasions, my lords.
Uh.
However,
What happened now? 11.
it's been adjourned. It will interim order needs to be extended.
CP. Take notice, hand summons on the 11. Same hand summons. Date is 15th. If it is filed 16th, stay granted or else stay granted earlier, stands vacated, extend the stay. Yes.
Lords, interim order extended. Please.
Yes. Where is this?
Checklist number 2. Pass over matter.
We'll see later. Let the,
List
where are
number
the officers?
They are settling the matter outside of the court.
Ask them to come.
But in first matter, pay and recovery order has to be passed. And court has, we have agreed to settle the matter for 3,78,000 plus 6%.
It's a case of?
It's a case of injury, Milord. They have also prepared appeal.
Bad. So, MFA,
9,500 is filed by the insurance company
hmm,
challenging the liability and the interest, future prospect was granted by 50%.
it's a case of death.
Injury case.
Future prospect of 50% is taken. So
And-
in 9500, you want pay and recover, and
Please.
the other one is
In their appeal, my lord,
compensation. Compensation, how much you are ready to pay?
instead of 3,28,000, it is 3,78,000 plus 6% interest.
78,000.
Please, enhance the,
Court had granted 3,28,000.
please,
No, please come to that calculation. We'll see.
please, madam. Para 36 make 26, I think. 26. Para 26, ma'am.
Para?
26. Pain and suffering 70,000.
What are the injuries?
Right hip with a femur comminuted fracture.
How many are the fractures?
Only one fracture, madam.
Right?
Right femur. Hip comminuted 1/3.
70,000 rightly granted. Medical expenses, any dispute on that?
15,300.
No dispute on that?
No. Conveyance nourishment attendant.
How many days he was in hospital?
Malad, as per the record, what we have totally more than 100 days he was in the hospital on different date.
Then?
Court has taken 25,000. Therefore, we have granted additional 50,000 under this.
It should have been 75,000.
No, but Malad, the disability is only 10%. Doctor assesses.
No, we'll go step by step.
Please.
In that 1 lakh we'll take,
Please.
as we are doing in all the other cases. Then
Please,
coming to the loss of income. According to him, what is an income?
Malad, he said the court has taken 4,500.
Which year is the accident?
11 accident.
2011. It should have been 6,500. So, how many days he was in hospital for how many months?
126 means 3 months. 4 months. Man.
4 months. 4 months after that for recovery, another 2 months. 3 months.
6.
3 months. 4 into 3, 4 into 3, 7 months. So 6,500 into 7. It comes to 45,500.
Please.
Then future earning. What is the disability according to the
10%.
doctor?
10%.
According to the doctor.
Doctor.
How much the court had taken?
Same.
Same was taken. So now we are taking the.
Come 6,500.
Why the future? It's a disability of 10%. Why the future prospects are taken?
That has to be that's the reason. Mala, considering all this, we have announced 50,000.
So if you don't take the future prospects, 6,500 into 12 multiplier.
17 multiplier.
First mute that, whoever it is.
17 multiplier.
17 into 10 by 100. It comes to 1,32,600. How much the court had given?
1,37,700.
No, the enhancement would be more than what your. Then loss of amenities. And
20,000 it is granted, 30,000 should have been. Considering all aspect, Malad, what we have suggested.
Still, it will be more than what your future medical expenses. What is the evidence of the doctor?
No, Malad.
Huh?
Nothing. There is nothing on the card to show that what is the
operation that must have the wins.
Yes, undergone operation.
Huh?
Yes, undergone.
So we will grant the same thing. 15,000. Then in that case,
future medical expense 15,000 is already granted.
But that's what will the same thing will continue.
Please.
That's what I'm saying. It comes to 4,08,400.
4,08,000.
It is, what is granted is 3,28,000.
Please.
You said how much?
3,78,000 plus interest, 6%.
6% anyhow will make it, but it'll come to 4,08,400.
Please.
So, what we'll do is, we'll, for a joint memo, Mr. Kusanagoda, for a joint memo, we'll refer it. And if they don't, with the same calculation, we'll pass an order. That pay and recover thing also, on what ground you are asking pay and recover?
But canter lorry was driven by the person who is not having a driving license to drive the vehicle. After the accident, he has renewed the license. Therefore,
What license he has?
Pardon me.
What license he has?
LME had. LME transport was there. It was expired. On the date of accident, there was no license. After subsequent to the accident, he has renewed that license. Therefore, on the date of accident, he is not.
What is the law on this?
The law is on the date of accident, it has to be valid and
Some
effective.
judgment. Recently, somebody has cited.
That's the reason pay and recovery order. On the date of accident, there is no license. Subsequently, he has renewed. But on that day, it is not valid.
Yes, Mr. What is that judgment? The other day it was placed before me. Just Nagaratna's judgment. It is there.
Renewed.
No pay and recover.
Okay. No, Mullah.
Huh?
No, Mullah.
had a license to drive it, let me transport.
No, that is.
Afterwards, it has been renewed. After lapse of 3 years or 2 years. This is not like this. They have only LME license.
They're sure that the judgment will not apply? Anyhow, that if they are not ready for that, then when it comes, we will pass an order.
Please, no problem.
Anyhow, on your appeal, we have to pass an both has to
Your
be.
court can pass an order here also.
Where is the advocate?
He has given the consent.
Oh, he's ready for that amount.
Yes, my lord.
No,
the problem is like, my lord, the 6% interest. When we have discussed with the advocate, we didn't know, my lord, 126 days he was admitted in the hospital. Subsequently, the amount what we have agreed, reducing 6% interest, pay and recovery. After we gone through, my lord, he was admitted in the 126 days. It is not fair enough for us to. That's the reason we have enhanced another 50,000.
It is submitted by the land council appearing for the insurance company that they are ready to pay an amount of rupees 4,08,400 at 6% interest. Then come in as per the, it is the case of the insurance company that the driver of the vehicle was not having the respondent is served.
Please, ma'am. In my appeal, he is served.
He was driving a canter
lorry, heavy goods.
But as on that day, he was not having the driving license. At a later point of time, the driving license was renewed, and even the earlier license is for a LMV.
Please.
LMV, considering the same, they shall be pay and recover. The pay and recover, and the interest is 6%. Refer this, and it is submitted that a joint memo will be filed before the Lok Adalat. List this matter before the Lok Adalat on what is the other date given yesterday? 22/4. Pin this. Next matter.
22/4.
Second.
Sale number 2. Sale number 2. O Mahesh. P.S. Kailash Shankar.
Yes, yours only.
Steps to be taken in respect of all.
Same insurance company.
Yeah. If they are ready, my lord, we are also ready.
We'll see what it is. This is the insurance company's appeal.
Please.
On what ground?
3, 2. No involvement of vehicle, my lord.
Then it can't be pose this matter.
Please.
Usual.
In the usual courts for final hearing. Yes, 3.
Sale number 3.
Who are the unserved respondents? You're seeking enhancement or liability?
Liability on the owner, my lord.
Is fixed on the owner.
My lord. Therefore, owner is 3 party.
Yeah.
But 2 RC.
List this matter in the usual course. Yes, next.
Issue notice to unserved respondent, madam. Already taken.
Already done. If you have done, it will be
Please.
not required to.
Cell number
Yes.
4, MB Chandrachуда.
7228.
What is this memo dated 6/2/2023?
Advocate for appellant has.
What is this memo? Look at it.
In this case also claim petition is dismissed.
Claim petition dismissed.
Annulment.
Yes, this is matter in the usual course. Next 5.
Cell number 5, SRBS.
Liability is on you or the
Liability is on us.
Insurance.
liability is on the insurance company?
We, in which case, my lord?
5.
5, sir.
Prasad. Yes, my lord. Yes.
It's on the insurance company.
Please.
Yes, let's see this.
It is a case of death, my lord.
What is the age?
Age is, my lord, 34 years, 16 multiplier is taken.
34 years.
16.
How much the trial court had taken?
6,000 income is taken.
Which year is the accident?
This is, my lord, 16.
Year of the accident 13.
413.
13 is, it should have been 8,000.
8,000.
Dependents, how many?
My lord, 1/4 has been deducted in this.
How many dependents?
There are 5. 5 members, my lord.
5 members. So, it's 8,000 plus 3,200.
Please.
11,200. Into 1, it comes to 3733. Is 7467 into 12 into 16. It comes to 14 lakhs 33,664. You said 5. 5 into, in Lok Adalat you are giving 40. Huh? So it is 2 lakhs.
2 lakh.
And
30.
funeral expenses 30,000?
30,000.
30,000.
$16 lakh 66,654. 16 lakh 66,654.
16 lakhs 66,664.
Please.
Same. This also.
Deal. There is no DL.
There is no
DL. Pay and recovery address.
There is no deal.
Tab, please.
Where is your appeal?
No. This is my lord, pay and recovery order.
Trial court has ordered.
Please.
Huh?
Please, my lord.
Where do you get that?
Madila.
In view of this,
please.
So exonerated and severally liable. The respondent number 3 is exonerated. The compensation is just for so and so. The petitioner. Respondent number 1 and 2 are jointly liable.
Please.
No pay and
No
recover.
pay and recovery.
It is submitted with insurance company that they are ready to pay an amount of rupees 16,66,664 and the enhanced amount, the interest shall carry 6% and both the parties shall file the joint memo before the Lok Adalat on so and so date. Give the date. No, we will go there. We will that will not be come here. I will go and sit in the Lok Adalat on that day. Yes, next.
22-4.
Yes, 6.
Cell number 6.
For the appellant, my lord.
Case
Case of injury, my lord.
Or R2 is deceased. Who is
He is
R2?
a driver, my lord.
And
Liability is on the insurance company.
Then, yes. This is in Kannada. So let's see, what is the amount? It's a case of
Please,
death,
my lord.
injury. Let's see, where is the table at least?
Table
Page 1.
LL. Judgmental page.
Page?
Please. There are 2 minutes.
There are two
32.
MFAs.
There,
This is arising out of
Please, madam, this is 32.
MBC 32.
Please.
Where do you get the table?
Table in 26, page number 2.
Page number 26. So, how much is given under the head of pain and
Pain
suffering?
and suffering, 1 lakh is.
What is the injury?
Not the injury we can. Albada, either judgmental way. Or so. Page number 17, he says that 12% disability to the.
So pain and suffering, how much is given?
1 lakh.
1 lakh. Then we'll continue that.
That is on the higher side.
Court appeal is not there.
But we have not prepared. Medical expenses,
yes.
91,008.
So coming to loss of future earning, which year is the accident?
10%.
Accident of the year?
2010, Malak.
2010. Court had taken how much income?
Total 3 months income 34,728.
She is a school teacher, continuing the profession. Therefore, court has granted only the loss of income during the treatment. 24,000.
Loss of income during later. Then we will increase it in amenities. Loss of income during later period. How much is granted?
34,728.
How many months?
Of 3 months, my lord.
30?
34,728.
728.
728.
For 3 months.
Loss of amenities, how much is granted?
It is 10,000. It is granted. It has to be increased.
Because the loss of income we are not considering. We'll take 40,000.
Please.
Then
Stay.
transport, nourishment.
40 lakhs.
Not given.
Future medical expenses, it is granted at 20,000.
That will continue. What about transport?
Conveyance, nourishment, attendance charges.
Not granted. How many days was in hospital?
17
days.
17 days was in. So we'll grant 17,000.
17,000.
Then any future medical expenses are granted. Loss of income, pain and suffering. So it's coming to
17 Mekala, 27,000 adding that Mekala and
medical expenses are there.
Please, Malad.
How much?
91,824.
91,824. It comes to 3,03,552. It is submitted 3,03,552. It is how much is granted?
2,56,552.
Land Council, appearing for both the parties, submits that the insurance company has agreed to pay an amount of rupees 3,03,552 and the enhanced amount, the interest at 6%, and both the parties will file the joint memo before the Lok Adalat on 22nd. Take this.
Bill number 7.
Please.
7.
It's a case of injury.
Number 7.
He has admitted in the hospital to
the file.
2/1 to 13/1/2014.
1 minute. Let me take first. Let's look at the table. Come to the table straight away.
Please.
What are the injuries?
Yes, first para 10 of the judgment, Malad. Yes. Right iliac bone fracture.
Pain and swelling of pelvis, bleeding around, so pain and swelling of left hip.
Acceptable
Walk or
fracture.
stand. How much is the disability?
disability was assessed 36% to the limb, 12% is taken.
As it is taken by the court.
Is taken.
So we will take this suffering for another 6,000.
2014
60,000 we
accident.
will take.
Please.
It's granted 50, we will take it 60. Then medical expenses, as it is. No, medical expenses, how much court has added everything.
It is not
Let's come to the
specifically
loss of
stated.
future income.
Like 10,004 and so on.
Now, medical expenses are here.
93.
Oh, and some of us reimbursed. It's not known by the remaining.
69,000 is reimbursed from.
I hold the entire for medical bills only to a tune of
12,563.
I think this is.
Therefore, considering that, Malad,
there is some lot of variation in this. According to them, 1,75,113.
Please.
Out of the 69,766 was reimbursed.
Please.
That is another 1 lakh is still pending. But court considers 12,000. I think this is a case for hearing.
Please.
List is matter in the usual course. Yes, next.
Cell number 8, B. Pradeep.
Yes, Pradeep.
Yes, not involvement of the vehicle is question whether I take steps to R2.
For taking steps to R2, a week's time is granted. This is matter after service of notice. Yes.
Cell number 9, Kalyan Kumar.
What about this?
Petition dismissed.
Huh? Dismissed. Dismissed. I'll post it in the usual course. No, not in the usual course. The appellant shall pay the process for service of notice to R1 and R2 within a week's time. Within a week's time, or else the appeal shall stand dismissed against 1 and 2.
Cell
Next.
number 10, N. Krishnaswamy. Cell number 10, furnishing of R1.
As per the postal share, notice to R2 is returned as unclaimed amounts redeemed service of notice. Then you are on.
As far as claimant is concerned, take steps once again.
For the appellant shall take steps in respect of the claimant within a week's time, or else the appeal shall stand dismissed against R1. Next, 11.
Number 11, H.S. Suresh Appagowda.
And in this matter, give the file. Have any information on this case? On 11? Second respondent is Sriram General Insurance. On 11, Mr. B.C. Sivanagoda takes notice on behalf of respondent number 2. And let's see whether the claim petition is 1,19,725 is awarded.
Please, we'll calculate.
We'll calculate. Pain and suffering 25,000 is granted.
Fracture of tibia.
Patella
fracture.
Two
Tibia and
fractures.
patella.
2.
Please.
60,000. Next, medical expenses. 48,525. How many days he was in hospital?
But 7 days in the hospital.
7,000. Then doctor was examined.
Please.
Any disability?
That's what I'm saying. No doctor evidence. Sorry. No evidence of doctor. But there are 2 fractures, my lord.
He was admitted in the hospital as inpatient for 8 days, not 7.
Pain and suffering needs to announce.
Huh?
Pain and suffering, they have granted 25,000. It has to be announced.
60,000 is granted.
Please. And
So then
community is not granted.
operation future medical expenses.
No evidence of doctor.
No, rod inserted has to be removed. That is evidence to that effect is there.
Correct.
Will grant 20,000. It is granted future medical expenses 45,000.
Immunity was not granted. That has to.
But no disability, no evidence of the doctor.
Considering loss of more 3 months.
A loss of income during later period. That's what I'm looking at. What is not added? A loss of income during later period. Which year is the case? 14? 14 is the accident.
Please.
8,500 into 3.
10.
10.
2010.
2010. Then 5,500 into 3. That is 16,500.
16,000. Conveyance attendance service.
That is already granted 8,000.
Please.
It comes to 1,78,025 from 1,19,725.
Please.
See, the land council appearing for the insurance company submits. The insurance company is ready to pay an amount of rupees 1,78,085, and a joint memo will be filed in this regard before the local adalat. Same 22nd joint memo. Next.
Sale number 12.
I pay for the appellant payments.
Amendment.
We have discussed this matter. Some sum of 1,25,000 will be deposited by me in addition to what is granted by MACT. We will be filing.
It is submitted by both the council that the insurance company is ready to pay an amount of rupees 1,25,000 in addition to what is granted by the tribunal. In this regard, they'll file a joint memo on 22nd.
22nd.
Yes, next.
Sale number 13. Suresham Latur. B. Pradeep.
No policy, they have to take steps.
List this matter. The appellant shall take steps for issuance of notice to R1.
Today only,
Huh?
Today only.
It is submitted that they've already taken, they will take the steps in the due course. This is matter after service of notice. Next.
Sale number 14.
In this case, the
Fresh mark. Huh?
Agree for 1 lakh in addition to what has been granted.
Cases of injuries.
Minor.
2,69,000 was awarded.
What is that?
2,69,000.
Now they are ready to pay another 1 lakh. We'll record it. It is submitted that the insurance company is ready to pay 1 lakh over and above what is granted by the tribunal, and a joint memo, same, 22nd. Next. Yes, Mr. V.C. Sivanagowda takes notice on behalf of the insurance company. Yes, next.
Sale number 15. Sale number 15.
Yes, 15.
Anil Kumar M.
Give the file. What about 15? Liability on insurance company?
If it is not. Please.
Let's see.
50.
Pain and suffering, court had granted 1 lakh. What are the injuries? Let's look at it. You have the details?
It is.
Yes. Court has fixed contributory negligence.
Oh,
They
another
have to be
company is
there.
there. Which company, my lord?
No. Contributory negligence
On the part
on
of
the
injured.
claimant. So for that, this is smarter. This is 15. No, the appellant shall take steps in respect of R2, or else the appeal filed against R2 shall stand dismissed. That is within 1 week. Next for 16.
Oh, 16.
Cell number 16, Suguna Reddy.
Am I appear for the appellant? Or your lordship may kindly grant a week's time to
Yeah,
comply
come.
office objection.
Satisfied the award.
Huh?
We have
Yes.
satisfied the award. Only enhancement.
Enhancement. We'll see then.
Two lakh 79,000 it is awarded.
How much is granted? 10 contributory negligence is there in this also. The step shall be taken.
Nandreli.
No step shall be taken in respect of
Dismissal.
R1 and R2 within 1 week. Same default order. Yes, next.
Cell number
Malad.
17. This is Shivanya Gowda.
Malad, in
Is
this
anybody
case-
appearing for in 16?
Malad,
Mr. So-and-so for respondent insurance company, Mr. Basis Sivanagowda takes notice. In that case, it should be only one respondent. Look at the file. Yes, next.
Malad,
Cell number
Serial
17.
serial number 17, we have challenged the negligence. I don't, ma'am, I will,
Non-compliance furnished so and
no,
so.
Malad, I will make my submission. The award amount is 10,000. There is a connected matter before the division bench. Therefore, considering that this decision is not binding on the other cases, on the basis of that observation, this may be dismissed.
How can it be? Why should we say that it's not binding on the other cases? When the court is giving a finding against you, why it shouldn't be binding you? It should bind you.
No.
This matter.
This is not the, since we have challenged the now your lordship can pass an order stating that.
You are saying that there is no negligence. Court will negligence.
There is a negligence.
Negligence on the part of
Part
the
of the-
claimant. No court will give a finding that there is no negligence on the part of the claimant and will dismiss your appeal.
The dismissal cannot be influenced. That's what my observation.
That kind of observation this court will not give. Yes, next. This is matter in the office raised on PF to furnish. The needful shall be done within a week. Next, 18.
Cell number 18.
What about 18?
This is
No, your appeal.
Shivanya Gowda, 18.
Liability. Liability under charge.
Liability is question on what ground?
But vehicle is not used under these.
The list is smart. You have to issue for steps to R1 to R3 and R5 a week's time.
Cell number 19.
Same default order.
Yes.
Yes, sir, 19.
Appearing for the,
Pradeep, please.
R7 is the owner of the vehicle.
Not necessary.
Not necessary. R3, my lord, Magma General
Who is
Insurance
filed?
Company.
Stating that respondent number 7 is the owner of the vehicle and the liability is fixed on the insurance company. Hence, notice to so-and-so is not necessary. Accordingly, dispense the risk of appellant.
So far as R3 is concerned, my lord, Magma General Insurance Company will serve the copies to Shivanya.
You are preparing for R3, so-and-so is directed to take notice and the council has served the copies on the council.
Next week, any date. Only negligence aspect, my lord. In the connected matter, my lord.
List is matter. List is smart. Then with that service is finished. Service to all
Service
the
over.
parties.
Oh.
Admit Lizzie's matter for final hearing. Could you call for the DCR? Yes, 20?
Cell number 20.
So only quantum is disputed, my lord. R2 is the owner of the vehicle.
Hmm.
The medical bills has been disputing.
Same notice to R2, owner of the vehicle, same dispense with, a memo is filed. Then this can be, this also has to go.
Please, my lord. Served unrepresented, not claimant.
Admit post of final hearing, call for the DCR. Next 21.
Cell number
21, my
21.
lord. In this case also, my lord. R4 is the owner of the vehicle. Quantum challenge. 15,000 income as considered instead of 8,000, my lord. ECM matter.
Then we will, I think a respondent is served, claimant.
Served.
We'll calculate. Same, take this memo is filed, seeking dispensation of notice to respondent number 4.
But when
Same is
Prabhakar,
taken on
some
record and dispensed with.
advocate is were representing Prabhakar.
So, let's come to the table.
Please. Para
The
issue
ECA.
number 4, my lord, para 14.
Para 14.
14.
Yes.
The disease was aged about 61 years. The relevant factor 113 of 77. The income considered, my lord, 15,000. It has to be 8,000.
Amount has to be,
8,000, my lord. It just has to be 8,000.
as per the notification, it is
Please, my lord.
8,000.
17/10/2013 is the accident.
8,000.
8,000.
So morning, some other case, somebody was saying 4,000.
4,000 below.
No, it was accident was
18, 12,
2013.
2000.
It was 2013.
10, my lord. Before 10.
It is 13, that accident was 13, passed over matter. So, like if the salary is 8,000, 50% has to be deducted.
4,000 into relevant factor.
4,000 into
113.77.
0.77.
Four lakh 55,080.
77 is 4 lakh.
55,080.
What, how much is, how much the court had granted?
8,53,275.
I think Liz's matter as
Further, my lord, further 15,000 as awarded, my lord, towards
and as per the
funeral
how much it should
expenses.
be?
5,000.
5,000. This calculation more hurdle and counsel for the appellant. No representation for the respondent, listed as parted on Monday or Tuesday. Yes. Next.
Cell number 22. Somsekhar KM.
R1. Yes. What about this?
Contributory negligence. Contributory negligence was taken. Sriram as well as Bharti AXA. Regarding R5 is concerned, Pradeep may be directed to take notice. R5.
Mr. There is no R5 in this.
TR Basavaraj.
Notice to R2, R3 and R4. R5 TR Baswaraju for R5 already served.
2275 of 21.
R1 Mr. Sivanagowda
Please.
is directed to take notice for R1.
R1.
Still R2, R3, R4 are to be served. Must be claimants.
Claimant Bharti AXA General Insurance Company, another party is there.
That is TR Baswaraj.
Yes. That is R5.
Please.
Manager.
According to you, in R2, R3, R4, any insurance company is there? Take that file.
R5 is the insurance company.
But that is already there. TR Baswaraj is there. Yes.
No,
But
TR Baswaraj is not appearing.
But that's what is, you must have filed.
Let us the Wakalat may kindly see. Illa. No such person.
R2, R3, for the process shall be paid for issuance of notice to R2 and R3 and R4. Within needful shall be done within a week, or else the appeal shall stand dismissed against R2, R3 and R4. Yes.
23. Nagaraja RC.
Yes, Mr. Krishnaswamy. Memo is filed seeking dispensation of notice to R1 and R2. Same is taken on record and notice is dispensed with. I think this is a case for an enhancement. We'll see. Pain and suffering. What are the injuries? Hmm.
Total compensation.
A sustained fracture of right femur and amputation of little toe. Court had granted how much? 50.
67,510 out of which
Pain and suffering 50 is granted. Contributor negligence is there.
there is contributing of 25%.
Okay. This matter, list this matter. I admit post for final hearing TCR. Case 24.
Serial number 24, Banu Prakash. E.T. Shivanya Gowda.
Liability on you.
Owner liability, owner liability on the ground that my lord, the driving license was not renewed.
No, liability is fixed on the owner of the vehicle.
Please,
On the ground that
no deal on the date of accident.
for even pay and recover also you should be served.
That's what.
The the needful shall be done within a week, or else the appeal shall stand dismissed against R2. Yes. 25 memo is for seeking dispensation of notice to R1 dispensed with
34 not 1.
25.
General insurance R2.
Here, my lord, I have made the note.
Huh?
34 pay and recovery.
20,
25.
25, sir.
That is
Sripath Viswas.
34 Sripath visas. These pay and recovery order has to be passed.
And he is not seeking for any enhancement.
No, yes.
Why pay and recover? Come to that particular paragraph.
My lord, driver did not possess
The
valid
DT as on the date
effective
of
driving
accident.
license. No
Contended
DL.
that The driver of the bus does not have any. Or the charge the bus does not have any.
Para 23 of the judgment. Section 181 has revoked. Charge sheet was filed under one.
Then already ordered, pay and recovery is
Pay
already
and
ordered.
recovery is ordered, that's what.
Then he has no, I think only for compensation. is before
Compensation
this.
enhancement is,
So let's see.
please,
Pain and suffering 60,000 is granted.
please.
The medical show that
He is working as a helper in a garage. According to him, he was earning 12,000.
petitioner had sustained degloving injury on the right foot and fracture of the malleolus right. 60,000 is granted. Then attendant charges,
25 days he was in the hospital.
nourishment, conveyance, 20,
25 days.
25,000. Then loss of income, how much the court has considered?
Notional income 9,000, 2017 accident.
According to him, what is his income?
He was 12,000,
According to him,
please, working as an
Accident is in
helper in a
2000?
garage.
2000,
17,
17, 11,000. Is already in hospital almost for a month.
Please,
11,000 into 4, 44,000. Then
medical bills, my lord, 11,725 was granted.
10,725. What is this loss of income, future income due to permanent disability not granted? No doctor is examined.
No.
Come
No,
to that.
No examination from the doctor. No disability was assessed.
So court had granted loss of amenities 15,000.
Amenities, that is the reason amenities was granted.
No future medical expenses.
No.
This is somewhere it is there.
60,000, so and so and so. Is put to nourishment over into 25 injury treated periods. So head of pain and suffering. No. No sufficient evidence so far for future medical expenses concerned. Para 19 of the judgment.
Yes, I've seen that. It comes to 1,90,725. How much is granted?
It is
1,72,000.
72,000.
List this matter before the
9% is
Lok
granted.
Adalat for filing joint memo on
22.
enhanced amount 6% on 22nd.
26.
All this calculation should be on the first page. Yes.
26.
Appellant.
Why appeal is also pending, not listed here.
The needful shall be done in respect of notice to R3 and R4. R3 and R4 are who? You have filed wakalat in this? R3 and R4 within 1 week, same, or else the appeal shall stand dismissed. Next, it is submitted that the connected appeal number so and so.
32, 42, or 22.
Let's post that along with the, ask him to write in a paper and give along with so and so.
Serial number 27. B. Pradeep.
Yes, Pradeep.
And
R3 is the owner of the vehicle.
Phone number 2.
We have raised the
Representing Shantaraj.
No, madam. Response number 2. Mother of the deceased
mother you are representing.
Why there is any dispute on that?
Please, my lord.
With regard to apportionment and all, there is any dispute?
Shantaraj is disputing.
Disputing.
Another appeal is there, connected appeal.
One more appeal is there, my lord. Santraj is
It has been
filed, my
clapped,
lord.
my lord. 6875. It has been clapped.
68, yes.
I'll
In
take
first-
steps to
in
R3.
27,
I'll take steps to R3, my lord,
in
because he has
27,
represented.
steps shall be taken in respect of R3 within a week, default order. Yes, post after service of notice.
Serial
Yes,
number
28.
28.
Yes, 28.
Syed Abdul Sabur.
I will let.
Give that, give the file.
Unauthorized passenger.
With call, entitled for compensation of 2,86,000.
Owner is
Respondent one is liable to pay 50% of the compensation. Will have to suffer
Please.
contributory negligence is there.
That's
The step shall be taken. Who others appear for this Sriram General Insurance?
the Pradeep is there
And
and Sitaram, N. Krishnaswamy.
Mr. N. Krishnaswamy shall take notice for the respondent insurance company. Which respondent is insurance company? R1. The step shall be taken in respect of R2 within a week, or else the appeal shall stand dismissed. Yes. R2 is in R2, so and so, R1 steps. 29.
Serial number 29.
Memo is filed seeking dispensation of notice to R1, and R2 is insurance company.
Out.
Look at it.
Bankman Shriram General Insurance.
Mr. Pradeep is directed to take notice on behalf of the respondent insurance company. And what about this? 29?
29.
Paid. Paid.
Because-
Satisfied.
Give that. I think it's a case of death. Court had granted 3,64,166. What is the age of the deceased? There are two claimants, I think parents.
Parents of the deceased.
The son of the petitioner. He was a student.
Please.
Then what is to be done? Is a school going boy?
Minor by.
Huh?
Minor by. Malad, issue is pending before the apex
That's
court.
why.
If they agreed in view of the other Supreme Court judgment, but now it is pending before the apex
Admit post of final hearing. Registry is directed to call for the TCR. Yes, next. 31.
30. In this case also insurance R2.
What is this? Liability on whom?
We have deposit paid money.
On the insurance company.
It can be paid.
Claim petition?
No, we have paid the amount, so it can be disposed of.
This is also case of death.
Minor.
No, that we have to see whether it is minor or.
That is it.
The petitioner is the wife of the deceased.
Then it can be disposed.
It can be disposed.
1/3.
Accident.
Age about 55 years.
Is 55 years. Accident is of which year? 2015.
So 9,000. Years, madam.
According to them.
Deceased was age about 68 years on the data.
Where do you get that?
It is in Tara 23.
20?
In
the petition has contended that the deceased was aged 55 years old.
Subsequently.
Huh?
Little.
Produce any document. The age of the PM report says 68.
68 is what has taken 5 multiplier was.
And earning 30,000 per month. Court had taken 5,000. So how much we have to take?
9,000.
2015, 9,000. No future prospects. 1/3 has to be deducted. That is
3,60,000. Instead of 2 lakh.
3,000. It comes to 6,000 into 12. Multiplier would be
5 months.
12 into 5.
Under the head of loss of estate.
It comes to 3,60,000. Wife is the only 40,000 and 30,000. Then it comes to 3 lakhs. Medical expenses.
But
No?
the loss of estate only 10,000 is granted. 15.
3,60,000 plus 430. How much is awarded?
2,65,040.
2,65,000 is awarded. It will come to now 4,30,000. It is submitted that the insurance company is ready to pay an amount of rupees 4,30,000.
Next month.
And for filing the joint memo, this matter before the Lok Adalat. For respondent, Mr. Sivanagowda takes notice for the insurance company. Take this. Yes, next.
Number 30, 31.
31, notice to R2 returned as unclaimed, amounts to deemed service of notice.
Right.
Yes, what about this?
There is a delay, my lord.
Huh?
Delay.
31.
There is a delay. Where is the delay?
Delay application.
31.
31. You are repairing
Pramod
31?
Gowda.
Yeah, one now is pending. Yes.
Satisfied, yeah.
That is
It
for
is
delay.
satisfied, Mala.
How much is the delay?
539.
Huh?
539.
530.
Denied.
IA number 1 of so and so is filed to condone the delay, same on condition. Then let's see.
Please.
Case of death or injury.
Injury. 20% disability state.
Where is the table?
Table, Malad. Para 32 is the table.
What are the injuries?
Issue number 2, Malad.
What are the injuries?
X-ray right foot shows fracture of second toe and abrasion over the wrist joint and CT head shows fracture of orbital of
Head
rib.
injury also.
Please,
So another pain and suffering will increase another 30,000.
please.
But salary considered 7,000. Salary is considered.
We'll come to the page number, para number 32.
No, I have taken.
Look at it, looking at it, you can submit. Then how much is considered the income?
Income malad,
He was there, how many days he was there in the hospital?
20,000 per, according to him, he was earning 20,000. His disability, neurological disability was assessed. Neurological disability was assessed to the extent
First
of
all,
69.25%.
disability, 60
9.25%.
to the whole body.
Neurological difference always whole body. Cannot be.
60?
69.25%.
Which year is the accident?
2016.
16. 9,500.
9,500. What is his age?
19.
31
years.
31 years, my lord.
Then future prospects have to be taken at 40%. 9,500. Future prospects come to 3,800. 13,300 into 12. What is the multiplier?
17
into you said
16 16 31
30
31
16 into disability you said 60
69%.
69
0.25%.
0.25
So can
by
respondent now.
it's coming to 17,68,368.
He was hospitalized for from 28/6 to 39.
How many
Almost
days?
3 months.
3 months he was in hospital. That is 90 days. So another 1 lakh under that. That is loss of income. Attendant also in the same lines. No, loss of income is not that. We have to take how much is the income? 9,500. 9,500. You said he was in hospital for?
Almost 3 months.
3 months. That is 90 days.
90 days. 6
Then another 3 months. It should be 6 months we should give. So 9,500 into 6. It comes to 57,000. Then attendant nourishment.
It is
Plus, so
1 month.
so
1
1 lakh.
month is granted.
Huh?
1 month is granted. 30,000 is granted.
How can it?
No.
No, that's what we will grant 1 lakh. So any future operations as per the doctor?
For that
Then
time,
loss of amenities, the amount that is granted is on the lower side.
it is not granted.
How much?
Nothing.
1.
15 is already granted. Another 75,000 may be granted.
No, we are giving the complete amount. When I'm saying 1 means 1 is including that.
Please.
Any future operation? Nothing.
No, my lord.
Medical expenses are there. Medical expenses 4,66,650. So
ಅವನ ಹತ್ರ ಇದೆಯಂತೆ ನಿಮ್ಮ ಹತ್ರ ಪೇಪರ್ ಇದೆಯಲ್ಲ But BCC.
It's coming to 25 lakhs, 82,018. Shall we pass it on the judicial side, this order, or is it okay for you?
Your lordship, it is better.
Huh?
It is judicial order better. It is better, my lord, because the award amount is on the higher side. It is better.
After lunch, we'll pass order.
Please.
On the merits, okay.
Serial number 38, 13 lakh 25,000.
1 minute. Serial number?
38, list number 1. 13 lakh 25,000.
38.
List 2.
List number 1.
List number 1 is also.
The one passed over matter. Passed over matter, serial number 38. How much?
13 lakh 25,000.
It is submitted to the insurance company, has agreed to pay 13 lakhs 25,000, and they'll file a joint memo. List this matter on 22nd for filing the joint memo. Huh? What is that? Huh? What is this? You don't come to the court, matter is adjourned, you'll move a memo now. Huh? What are those matters? What is the matter?
Challenging the order passed in
95.
Why, where this court is having the roster for writ petition? You were thinking something which was 6 months back. Writ petition, this court has no roster, Mr. Counsel. Go before the other court. Yes.
Lord, serial number 95, my lord.
20?
95.
85.
95, my lord.
95.
3 lakh 12,000.
3 lakh 12,000.
95. Same. 3 lakh 12,000. Same 22nd.
Please.
Any other matter?
73, my lord.
73. Yes.
The claimants as well as company appeals, both we have withdrawing.
Both. Oh.
Shankar Shastri, he has also agreed.
Then they have to sign that if it is, they want to withdraw.
Before my lordship on 230.
230.
Avala 230.
And 83 also settled.
Which one? Yes.
230 will mention, my lord.
83.
We will mention the afternoon.
We'll continue the list.
Please.
We have to complete the list by 4:30.
Lords, on submission.
Yes.
My Lords, on submission, my Lords. List number 2, serial number 51. Senior brother is not feeling well, my Lords, on short adjournment.
No, we are not deciding anything on the merits of it.
The claimant petition got dismissed, my Lords. Call for the TCR.
That anyhow we will do it.
There is no TCRs also, my Lords.
No, it is urgent. We don't want.
What are those password matters?
Serial number 4. MRE method.
Audio is not, we are not getting video, Melon.
Sorry, madam. The minimum wage is.
Where is the council?
Melon, video is not working.
That is Mr. Nagaraj.
Yes, Melon.
Some other.
Yes, I got it, Melon.
Where is he?
Video on there.
This is matter after vacation. Little from Bartlett. Yes, next.
Serial number 16. List 116.
Yes, 16.
Serial number 16.
This also after vacation. Yes.
Serial number 24.
Mr. Nagaraj, all
Nagaraj.
the insurance company council, they are there. It will take some time. We'll have this matter some other day. All this also adjourn after vacation. Yes.
Serial number 39. 39.
Yes, 39.
39. First settlement.
Raj Patil. 39 post in the usual course, or 39 is referred to Lok Adalat. Yes. Yes.
List number 2, serial number 31.
30. The present petition, the present appeal is filed, agreed with orders passed on MVC number 8343 of 2016, dated 1st June 2018. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs on account of the injuries sustained by the claimant in the road traffic accident. It's a case the tribunal had granted the compensation as per the table given below at para number 32. Learned counsel appearing for the claimant submits that under the head of pain and suffering, considering the injuries and the disability that is sustained by the claimant, the tribunal had not granted a reasonable amount. Coming to the loss of income during the later period also, this accident has taken place in the year 2016 and court had taken the income at rupees. Yes, Mr. The income was taken at
7,500.
7,500.
is taken at rupees 7,000. Further,
But 7,500.
when it comes to the loss of future income, it is submitted that we have sustained 69.25% disability.
Court has taken
And 69.25% disability.
neurological.
The court had taken it as 20% to the whole body and granted the compensation. It is submitted that the disability ought to have been taken as a full body disability, but it can't be considered as a as a limb disability, and taking 20% is on the is not is contrary to law. Further, it is submitted that he was in hospital for 126 days. 126 days, and the court has not granted reasonable compensation. Further, in the head of loss of amenities also, for the disability of 69.25, the court had not granted the reasonable compensation. Next parallel, and counsel appearing for the insurance, which is this case 30.
This
1620. Learned counsel, learned counsel appearing for the insurance company submits that the tribunal had granted. Tribunal had.
Anup Sitaram Rao.
The tribunal had granted reasonable compensation. There are no grounds to interfere with. In this case, the claimant had sustained injury to the head and lapsed into loss of consciousness since then. He had sustained multiple abrasions over face, right shoulder, right wrist, cut lacerated wound over the right eye swelling with black eye, deglowing injury of the right foot. He was admitted in the hospital as inpatient in the ICU, and the CT brain shows severe traumatic brain injury, multiple hemorrhagic contusions in bilateral cerebral parenchyma, left basal ganglia and corpus callosum, extradural hematoma in right temporal region, diffuse axonal injury, multiple fractures involving the right maxillary sinus, right zygomatic arch, sphenoid wing, multiple facial bone injuries. He was managed in ICU with conservative treatment for traumatic brain injury, which included anti-edema medicines, anticonvulsant, antibiotics, antacids, and intravenous fluids. He was on ventilator in ICU. In view of the long-term ventilator support, tracheostomy was done on 1/9/2016 and devolved lung infection and treated with appropriate antibiotics. He underwent wound debridement, orificeal bone and K-wiring on 29/8/2016 by plastic surgeon and the orthopedic surgeon. He was there in hospital for 126 days. Considering all this, under the head of pain and suffering, this court is granting 90,000. Coming to the loss of income during the later period, this is an accident of 2016, and he was there in hospital for a period of 4 months, and for the next 3 months, for a total period of 7 months, this court is granting 57,000. Coming to the disability, when the doctor had deposed that he is having a neurological that he has as per the neurophysical assessment, which reveals impairment in inadequate memory, language problem, slurred speech, and poor reasoning. And he has IQ of 57, which in the range of moderately below average. And the disability is 69.25%. Court had taken 20%. In the considered opinion of this court, the 69.25 should have been taken as a whole body disability. Hence, under the head of loss of future income, 6,000, what is that? Should have taken 69.25 as a whole body disability. Coming to the income, as this court has taken the income at 9,500, future prospects at 40% will come to 3,800. Then has the income would be 13,300 into 12 into 16 into 69.25 by 100 is 17,68,368 towards attendant and nourishment for the 126 days. This court is granting an amount of rupees 1 lakh. Loss of amenities, the tribunal has granted 15,000, considering the disability of 69.25%. This court is granting an amount of rupees 1 lakh towards medical expenses. Court had already granted 4,67,650 and no interference is called for. And in the light of the law laid down in so and so towards legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 25,92,018. Accordingly, the appeal is allowed and the enhanced amount shall carry 6% interest. Next.
Serial number 32.
Yes. What
Satisfied.
about this?
Award is satisfied.
Yogi Bhatt.
Award satisfied.
Let's see.
High value.
Page number.
That, salary is, so far as salary is.
No, where is that?
The salaried person. Working in a BBMP as a sweeper. Salary was taken 21,000.
It's a case of injury?
Death case.
Death case. Salary is?
21,348.
343. After the statutory deductions?
Please. Future prospect was not taken.
Not added.
39
So please
years.
come to that particular paragraph of where the
Para number age is concerned, page number 18 of the judgment. 90. Disease comes to 14,000 since the total salary not exceeding the taxable income, and there is no question of deducting income tax from the salary.
earning sum of 15,000 reducing.
15% comes to 7,000 net salary. So after deducting professional tax comes
No,
to
it is about 9,742. The court discussion is. Come to internal page 16.
Please.
To prove para number 13. To prove the income and avocation of the deceased.
Please.
And earning 15,000 per month.
15,000 per produce the exhibit P9 salary slip of 23 13 drawing
And
gross salary
drawing gross salary and after deductions
82
4640
net salary was taken
9742. What are those deductions? We have to see.
they are not the income tax assessed except professional tax. They are not liable
That's
to
what
pay
I'm
any
saying.
tax.
So what is
randomly considering that the court has taken EBMP 10 years disease was confirmed, so and so. So they have taken what their salary was taken, future plus was added, already is added.
no salary was not taken at 21,000.
So what they done was below 40 years. In addition, should be only 30%. It should be 50%.
First of all, give me the clarity with regard to the income.
Salary.
The salary, how much the court had taken.
Please. That 14,383
Was taken.
50% was
14,382 was taken as salary.
Please.
Who are the claimants? He is
two sons.
Wife, sons, two sons, three. 1432 plus 50%. He is working in BBMP.
That's what they have taken, my lord, 348, 21,348. After deducting the
So you
professional
are saying
tax.
that for without future prospects, that was the amount.
No, like page number 19, it is mentioned that this is come to salary 14,332. Since the total salary not exceeding taxable, hence there is no question of deducting income tax for salary of the deceased. 50%.
So his salary will come to 21,573.
Less professional tax.
Where is that? That we have to see.
So all the salary person has to pay the professional
Correct.
tax.
How much is that?
200 rupees.
So 2157.
1,400 rupees per year.
And 2,000?
400 per year.
2,400 per year.
Per year. Or 200 rupees has to be deducted from the salary. That's all. 21,000.
21,573 means that 21,373.
Please. One third has been deducted.
It comes to 7124.
Please.
It comes to 14,249 into 12 into what is the multiplier? Multiplier is
50.
It comes to 25 lakhs 64,820. Tell him. So consortium.
Oh my sir. Sir, ನಿಮ್ದು mute ಮಾಡ್ಕೊಳ್ಳಿ sir.
3 into 40.
Whenever you are not in proceedings.
30,000 funeral expenses. Any medical expenses? Died on the spot?
But in the judgment, there is no award regarding.
No. Where do you get the table?
There is no table in this.
Huh?
They are not given the table. But, exhibit P5.
Loss of it.
2,160 rupees medical bills was. 2,160 medical bills.
160 medical bills. But it is not granted, I think.
It is granted, madam.
No. There are particulars are there at first. Loss of dependency 25,61,000 was granted.
Please.
Consortium 20,000 was granted.
Correct. Towards the loss of expectancy 10,000 is granted. 2,160 medical bills was.
Medical bills 2,160.
So loss of consortium 40 into 3.
It comes to 27 lakhs.
Placement.
16,980. How much is granted?
26 lakh 13,920. 26 lakh 13,920.
It is submitted by the insurance company that they are ready to pay an amount of rupees 27 lakhs 16,980 And the tribunal had granted 26 lakhs 13,920 for filing the joint memo.
Delay. Delay is there. And
Delay, how much is the delay?
it is not mentioned here.
Look at it.
Say that it's only.
Same 2001, IA number 1 of 21, 2141 days, not entitled for interest, the same this also. Yes, next. Joint memo on 22nd.
Serial number
Yes.
33, Pradeep B.
Who is R3?
This is owner of the vehicle, madam, challenging the liability.
Liability. The petition, the appellant shall take steps for R3 within 1 week.
Claimants also filed an appeal, my lord. MFA 1066.
List along with.
1066 of 2020.
List along with so and so. Yes, next.
22.
Yes,
Serial
next.
number 34, Shripad B. Shastri,
Yes, what about this?
Ramya M. Pradeep B.
30.
It's a short deadmanship, senior ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ weak accommodation.
You are representing Shripad V. Shastri.
Lordship appeal and KSRTC lordship.
Yeah,
Ramyan,
She's appearing for the
KSRTC.
The liability,
KSRTC.
contributory negligence has been fixed, my lord. Not contributory. Liability fixed against KSRTC 50% and insurer of the offending vehicle 50%. Lorry.
Vehicle involved is KSRTC.
Both vehicles. KSRTC passenger
Notice
sustained
the
injuries.
appellant shall take steps respect of shall pay the process for R2, 4 and 5 within a week. Same default order. Yes, next
Serial number
35.
35, PC Shivanya Gowda.
This case, my lord, the insurance company is challenging the award under the injured was not a employee of the cleaner in the insured vehicle. Thereafter on in the observation of the court and the medical record, police record, he was proceeding in the we taken the contention passenger in a goods vehicle. But in the medical record as well as the hospital record, it says that he was proceeding as a cleaner. Interest rate is granted 7%, my lord. It has to be reduced to 6% and closed.
You that. Where is that finding?
That finding, my lord, the para 24, para 24, my lord,
24.
In page 30, in page 30 of the judgment, my lord. Next page. In page 30. Page number 22 of the judgment. Middle of the, in the police.
Agreed with orders passed in MVC number 7533 of 2018, dated at 17th March 2022, the insurance company is before this court questioning the liability. It is a case for the insurance company that is a claimant or the deceased?
Claimant.
The claimant is not the employee of the first respondent, and the vehicle has no permit to ply. On this, the tribunal had given a finding that the claimant has produced Exhibit P16, the attested copy of the temporary permit issued by the motor vehicle inspector, Alampur CP Joglamba, Gadwal district, Telangana state. As per Exhibit P16, validity of the permit is from 11/9/2018 to 10/10/2018, and the accident had taken place on 14/9/2018, and the tribunal had held that the vehicle is having a valid permit to ply in Telangana and Telangana state to Karnataka state. And further, the medical records, the name of the claimant is shown as Hema Reddy, son of Lakshmi Reddy. In the Aadhaar card also, the name of the petitioner is shown as Hema Reddy. In the wound certificate also, similarly, the name is shown.
Hema Reddy.
But only the charge sheet is shown as Hema Reddy. The court has taken that due to mistake, only the name is wrongly entered. Even as for the police records, the claimant was a cleaner of the offending vehicles. the court came to the conclusion that the said contention of the insurance company that he is not the owner, is not an employee of the first respondent, is without any basis, and held that the insurance company is liable to pay the compensation. Next parallel, and counsel appearing for the insurance company had submitted in the similar lines and submits that the insurance company is not liable to pay the compensation. It is further submitted that the rate of interest is 10%, which is on the higher side, and the same needs to be reduced. Next parallel. This court has perused the order impugned, having heard the counsel for the appellant. This court had perused the reasoning given by the court with regard to the liability. The court had rightly come to the conclusion that the claimant is working working as a cleaner in the said vehicle, and no contra evidence is produced by the insurance company. Court had rightly considered the police records and other documents, and this court finds no reasons to interfere with such a finding. As far as the interest part is concerned, the interest is reduced from 7% to 6%. Accordingly, the appeal of the insurance company is partly allowed. The amount in deposit shall be forthwith transferred to the trial court.
36, Ramya HN.
Yes.
Connected to 34 serial number.
Post along with the 34.
34 serial number.
Right.
Yes, Nick. What about notices in this also?
Please.
The steps shall be taken in respect of 3 and 4. Needful shall be done in respect of respondent number 3 and 4 within a week. Next, 37.
Till number 37.
Please.
37 I'll appeal for appellate.
The case of injuries.
In
the
this
data.
memo is filed seeking dispensation of notice to R1 and R3. Same is dispensed with at the risk of appellant. Give the file. Yes.
But in this case, as per the
It's a case of
Injury.
petition, my lord, dislocation of left knee.
Where is the table?
Page number 25 in last your last.
What are the injuries?
My lord, dislocation of left knee. Subsequently, my lord, they produced some document that was rejected by the court on the ground that, my lord, the treatment which was taken by the petitioner is not for the injury which was sustained in the accident. Dislocation of knee. Here, my lord, ankle injury, he has produced some document, treatment. That was rejected.
Now, your lordship, the Victoria Hospital, Ramchandra examined you as a treated doctor, your lordship. That is, the one is the reduced posterior dislocation of left knee, and the popliteal artery injury with knee injury, wound explanation, and popliteal artery repair and
Was the
examination.
doctor examined?
Dr. S. Ramchandra.
He has
Let's
not
see.
treated.
Yes.
What was his
Victoria
evidence?
Hospital orthopedic surgeon, your lordship.
He is orthopedic surgeon, my lord, but he has not.
If
He
it
has
needs-
stated.
No, if all these things have to be taken, we'll see it some other.
Please.
So and so, admit, post for final hearing. Yes, next.
Till number 38. 38, Sushmita G. No, for
So
dispensation.
she was a memo is filed seeking dispensation of notice to R1, dispense with the risk of
Correct.
appellant. This is with regard to dismissal of,
Already settled.
morning mentioned. Yes.
1 lakh.
Memo as far as dispensation, and it is coming up before the local. Morning, the other.
We have already
stenographer has
deposited the award amount also.
No, my lordship, it is like.
It has to be dismissed.
That is 38 in the other case. Oh, what happened to this?
During Lokadalat, we are settled, during Lokadalat, we are settled for the 1 lakh and we have deposited the amount.
But
I mean,
case
joint
was
memo is
not
not
disposed
filed.
of.
We filed joint memo and we have deposited the amount also for the lower court.
Then
but
how
now-
come it has come today?
Even-
Where is that? You have the that order?
Yes.
So pass on that. Any order for referring it to Lokatala? Verify it in the meantime. Call this matter again. Yes, 39.
Serial number 39,
39, my lord, notice to R4 may kindly be.
TB.
Memo is filed seeking dispensation of notice to R4. Yes. You are on
Next
what
week.
ground?
Next week. my lord. Quantum only, my lord.
Quantum.
Quantum.
We can decide it by next
Please.
week.
My lord, in case of death, my lord,
Where is
that
that?
claim by,
table?
my lord, major sons, my lord, married daughter. 14,500 income taken. He was aged about 60 years, my lord. 10% future prospects has been added. Internal page 10, my lord.
No, are you sure now? If you do the calculation that it would be less than this,
That's what.
it will be?
That's what for next week. Let's do it.
It won't be less than that. That's why we will see. So what is his income?
10%.
No, what
future
is his
prospect.
income?
Income as per chart has been taken. 14,000.
How much it is taken?
14,500 only.
14,000?
Same has been considered. 19/9/2019 is the
No,
RC.
14,000 is the income.
14,500 as
500
considered.
is the income. And what is his age?
60 years.
60.
60.
Court had taken future prospects.
10%.
Then what about other conventional heads?
Other conventional head, 40,000 each has been granted.
How many are the
2 million. Son and daughter.
loss of estate, the funeral expenses?
That's
Here
also
they will get about 6,000. Here they will get
That's also it will reduce 10%.
still the amount will be reduced.
Please.
This matter as part heard on Tuesday. Heard the counsel for the appellant.
Serial number 41,
No representation.
1 and 2 are the claimants. I will take steps to.
For taking step for R1 and R2. List this matter, not list this matter, a week's time. Default order.
Seeking dispensation of
Serial
notice
number
to
Which one?
41.
41?
Serial number 41, 4529 of 2020.
Oh, in the other matter. MMO is in 41.1. MMO is file seeking. Memo is file seeking dispensation of notice to R2. Accordingly, memo is taken on record. And notice to R2 is dispensed with. This is on what?
My lord, I have quantum and negligence. They have also filed an appeal for enhancement.
In 41, steps shall be taken in respect of R1 a week's time, or else the appeal shall stand dismissed without further reference to the court. Next.
serial number 42. 42,
What about 42?
Banu Prakash, PC Shivane Gowda,
Yes.
It is satisfied, my lord.
We'll see. Give it. What is the age?
In the claim, connected appeal, claimant appeal was there, my lord. In that, we have already satisfied the award.
Liability was shifted on us.
We have accepted the liability.
You have accepted the
We
liability.
have accepted. Liability was fastened on the owner of the vehicle. Considering the trend of the court, my lord, we have already satisfied the claimant appeal. This is the owner appeal. Appeal may be allowed and the liability.
What is the owner's appeal? The present appeal is filed. Agreed with orders passed in MVC number 306 of 2014, dated 6 April 2016, by the owner of the vehicle, the liability is fastened. Liability is fastened on the owner of the vehicle. The same was questioned by the claimant by filing
In appeal number
MFA number 7195 of 2017.
Please.
And this court by order dated 28th July 2023 has allowed the appeal and held that the insurance company is liable to pay the compensation of an amount of rupees 7,55,880 in the light of the order passed in MFA number 719 of 2017. This appeal is allowed, holding that the insurance company is liable to pay the compensation. Yes, next.
Serial number 43.
43, my lord, in this case, this was traveling in a tractor mudguard. Risk is not covered, it may be at.
IA number 1 of 18 is filed to condone the delay of 184 days on condition. Admit post for final hearing.
Serial number 44.
Yes, what about this?
N. Krishna Swami.
My lord's issue is with respect to loss of future earning capacity.
Future earning capacity.
Case of injury, my lord.
And what is the disability?
Disability is, the doctor has assessed it as 90%. I mean, there's a permanent disability, my lords.
To the body at
To the body.
90%. Court had not granted.
My lord, I have filed this appeal challenging the excessive compensation granted.
How much is granted?
My lord, 9,16,000 is granted. 16,000.
In a case of 90% disability.
No, not in 90% disability. My lord, the injury sustained by them, fracture of clavicle, right distal end radius fracture, and brachial plexus, which has resulted not in any paraplegia. Paralysis is there to some extent and is not having the.
As per the evidence of the doctor, what is the disability?
My lord, the evidence of the doctor would indicate. I read the evidence. P6 is the wound certificate and
The chief examination
evidence of-
affidavit. Chief examination affidavit of CW.
anyone can read. If you want, you can read it. My lord, the evidence indicates Dr. B.S. Raghavendra.
As per the wound certificate, the petitioner has sustained 3 fracture injuries. Court had granted 30,000 towards loss of immunities.
All these injuries were grievous
First
in nature.
20,000 towards conveyance, 40,000 towards loss of earning during the later period. Pain and suffering 60,000. Medical expenses 39,000. Loss of future earnings 7,26,957.
Please, ma'am.
So,
Subsequent to the accident,
On the basis
his
of
income
IT
is not
returns which are
diminished.
filed.
huh?
Subsequent to the accident, income tax returns itself would indicate that income has not diminished. He's a commission agent. He is getting more than what he was getting earlier. That is the reason why I said that compensation granted on.
For example, a person, because of the injuries sustained in the accident, he had sustained a disability of 50% to the body. That disability is always a disability.
That is a disability, but it is not a functional disability. That is, financial loss has not occurred in such circumstances. But this court can grant compensation under that disability, but not under functional disability.
My lords,
Therefore, that has to come down.
my submission, my lords, to counter that, I have filed 2 IT returns acknowledgement, my lords, for the assessment year 2015-16 and 16-17. The latest one is 16-17. 16-17 assessment year IT returns I will pay for the financial year 2015 to 16, my lords. Now the year of accident is 2016, which is prior to my accident. This is not IT returns which I have filed post to my accident.
Melody, one IT returns that he has filed is subsequent to the accident. One is prior and another is subsequent.
Which year is the accident?
My lord, the
2016,
accident-
my lord.
16.
Date of the accident.
Date
November.
of the accident is, my lords, 27/11/2016.
That is almost 2017.
2000.
Please.
Now let us see the exhibits. Which is the exhibit?
Exhibit,
Come
my
to the
lord.
order.
Exhibit is P66 and 67, my lords.
Income tax returns. You
IT
have
returns.
the, take it.
16 and 17.
Exhibit P66 and
66.
67.
66 and 67.
ಅದೇ ಅದಲ್ಲ ಅದನ್ನು 64 ಅಲ್ವಾ
2015-16
15.
assessment year. He has sustained injuries in the end of 2016.
Now,
Next is 16-17 assessment
16,
year.
17.
16/17. The financial year is 15/16. So, my lord, here the
That date of filing this assessment is 14-10-2016.
16.
By that time, he didn't even met with an accident.
My lord,
Want to see?
my lord, the basis is he has suffered loss of income. No document is available. He had income. To that extent, documents are available. My lord, this is
Show it to him.
My lord, one submission, my lord.
magnanimous and generous. It has come up before a magnanimous and generous judge. There is reason why.
My lord,
My lord, one thing could be done, my lord. According to me, if
Both
that
appeals
is
should
not
be
a
dismissed.
positive point on my side to get it reduced, my appeal and his appeal, both.
That's what I understood. But why would he ask his appeal to be dismissed when he has a fair chances of success?
My lord, in fact, disability.
In
fair
that case,
chances.
we'll just see whether there is any scope or not. Come to the table. Now, pain and suffering, 60,000 is reasonable for the two injuries, two fractures.
Please,
Then medical expenses, you are not disputing.
please, my lords. My lords, I'm only disputing
But that's
loss.
what, we'll just come head by head. Loss of future earning capacity.
Please, my
For that, you come to the discussion part. Which para of the trial court judgment?
My lord, para 26.
28. Please read.
My lords, para 26.
26.
26, my lord.
Read.
The petitioner has contended that he was doing business and earning more than 30,000 per month. It is forthcoming in the evidence of PW1 that he was working as a LIC agent and a vehicle insurance agent, and therefore he was earning more than 30,000 per month. In order to substantiate the same, the petitioner has produced TDS from bearing number 16A, and they are marked as exhibit P60 to P64. The petitioner has also produced Indian income tax return verification for the assessment year 2015-16 and 16-17, and they are marked as exhibit P66 and 67. As per the documents at exhibit P60 to 66, the petitioner has shown gross total income of rupees 3,69,170 minus deduction of rupees 1,48,884, total income of rupees 220,290, and paid tax of rupees 54,316. My lords, this is what I am saying is wrong. Because, my lords, as per the IT returns, my lords, which my lords refer to at exhibit P66 and 67, my lords, gross total income minus the tax payable amount will be the net income, my lords. Now, what the learned tribunal has done, it has deducted the deductions under chapter 6A, which is mentioned as 1,50,000 minus the gross income, and it has taken the net income, my lords. This is what my case is.
So, what is your total income for the year?
My lords, for the assessment year 2015-16, the gross total income is 3,69,170, and the tax payable amount was 0. It was assessed as 0. I have not paid any tax. So my net income will be 3,69,000 change, the gross income. And for the assessment year 2000,
No tax.
no tax.
Hmm.
For the assessment year 2016-17, 4,09,148 is the gross income.
4,09,000.
148.
Hmm.
And the tax payable was 0.
Hmm.
That means I am within the slab, so I have not paid any tax.
Hmm.
So the gross income should be considered, my lord. So I have taken the average of both.
He has produced.
So your monthly income would be
32,430.
30?
32,430.
Hmm.
Whereas the honorable, the learned tribunal has assessed it as 18,000 change.
Each year he has paid. TDS certificates are also produced. TDS certificates are also produced by him. Tax is deducted at source. That is the reason he is not paying any tax. Around
You find in that.
my lord, 60 and
Better look at the record, Mr. Counsel.
60 and
Better look at the record.
I have produced TDS.
So what does it mean?
Lords, TDS is what I get the concession in tax when I file IT returns. My lords, that is not the factor which should be considered. My gross income, my income is 4 lakh change. And for the assessment year 2015-16, 3 lakh change. So once the tabular column in the IT returns, it is shown as tax payable 0. Then TDS has
Already the tax is paid at source. That's why you don't have to pay tax again. Isn't it?
No, that is not, as per my understanding, that is not how it is.
we will look into the documents.
Because
List is matter on Wednesday.
Wednesday, please.
23/4.
28.
Yes, 45.
Till number 45, AS Girish. AS Girish.
Liability, my lord.
Liability. I number 1 of 19 is filed to condone delay of 298 days in filing the appeal. What's his name? Usual orders will be there for condonation of delay. I'll take from them. Accordingly, condoned on condition. Yes. And post for the admit, post for final hearing in usual course. Yes,
Till
next.
number 46.
Please respond. In this case, my lord,
51 and order.
2013 accident, they have filed the appeal for enhancement.
Your where is their appeal?
46.
46.
45, 45.1. Oh.
46.
Hmm.
And admit final hearing.
Pay and recovery.
That is admitted.
Pay and recovery.
46 is pay and recover.
Pay and recovery.
Let's see.
Judgment kodu, judgment kodu.
Where do you get that? Discussion with regard to liability.
Regarding the vehicle was not having a permit to play.
Transport, non-transport, Mukund Devgan, where is pay and recover?
Not the DL, my lord. Permit.
Come to 54.
No, we have taken two contention, my lord. One is driving license, another one is permit. In one of the-
Where is the finding with regard to permit?
Given.
47.8 is the admit. 478.
Come to paragraph 52, we will read.
Please.
You have the file? The respondent number 1 deposed that the driver of the offending vehicle had no valid and effective driving license at the time of the accident. Nothing else.
Like that. 53. 53, my lord. The exhibit P accident report showed that Babu managed road Ganguly so driver, New India so DL investigator DL could be so and so. DL la Pramesh Babu so and so Ganguly, DL valid so and so. Regarding Maruti engine so and so.
No, next 54 the discussion
permit
is.
in respect of particular vehicle.
Correct.
Vehicle, Contract carrier shows that respondent one has vehicle having a registration motor car. Validity is expired to 72 days. Therefore, respondent one has permitted to play on the road. Scheduled route. Scheduled route, state Karnataka except. So, right. This may be have done Monday. I brought my file. It was not raised. I am not.
Look at it. Give him this file.
I am not.
Pass over. Yes, next. There is nothing in that.
If it is there, my lord, I will withdraw my appeal.
You can withdraw. Look at it. Casual appeal. Yes, next.
Cell number 47, Gurudev Prasad KT.
Yes, Pradeep.
Company appeal is also there.
There. Post along with so and so. IA number 1 of, give the number, post along with so and so. IA number 1 of 22 is filed to condone the delay of 99 days in filing. Delay condoned. Admit post of filing. Call for the TCR. Yes, next. 48.
48,
60 days delay may be condoned, my lord. TCR is required. Claim petition has been dismissed.
Dismissed. IA number 1 of 22 is filed to condone the delay of 60 days in filing for the reasons stated in the accompanying affidavit. The delay is condoned. Admit, call for the TCR. Next.
cell number 49,
What about 49?
PJ Sumkapur.
Claimant's appeal, madam.
For enhancement?
Enhancement, madam. Case of injury, madam.
Then 2 appeals are for enhancement.
Madam.
There are 2 appeals.
Yes, madam. One is in a simple injury, madam.
Hmm?
First one is 7939, madam.
Hmm.
That is grievous in nature, madam.
Hmm.
Date of accident is 11/1/2019, madam.
1 minute. This is MBC number?
Commission number 397, madam.
397.
Yes, madam. 397 of 2019, madam. Both are common judgment, madam.
No, but the compensation would be different.
Page number 30, madam. Ink page number.
30. This is with regard to the first case.
Yes, madam.
MBC number 397.
Yes, madam.
What are the injuries?
Injury, my lord, fracture of left leg knee, 1/3 knee, fracture at the junction of middle 1/3 distal.
Shivanagoda, next, this part of
49. 49. And fracture of left femur, my lord. Notional income is 14,000, my lord.
First of all, we'll see what are the injuries.
Please, madam.
In order to support the petitioner place exhibit P5,
Yes,
which is wound certificate given by the government hospital. Sustained fracture on a left leg knee, 1/3, and was unable to walk. So, court had granted pain and suffering 20, will grant 40.
20,000 is granted.
40. Next, medical expenses, no dispute.
No dispute.
40,066. Attendant, how many days he was in hospital?
12 days, my lord. 12 days, my lord. Only 6 days is considered. 12 days, my lord.
12 days. Court had granted already 11, not more than that. 5, 5, 10 plus 6, 16 court had granted. So we leave it there. 655, that is 16,000. Then loss of income during laid up period. According to you, what is your income?
14,000, my lord. Notional income.
14,000.
Yes, my lord.
According to you,
Yes, my lord.
Hey, according to him pleading.
according to the claimant,
Claimant, 15,000 we have claimed, my lord. Notional income is
2019 accident.
19.
14,000
14,000, only 1 month given, my lord.
into, how many days he was in hospital? 11 days.
12 days, my lord.
12 days, 14 into 3. 140 into 3, 42,000. Next, loss of future earning.
Yes, my lord.
Come to that discussion.
Discussion, my lord, page number 28, my lord.
28.
27.
What's loss of future earning? 20 to 25% to the left lower limb,
On disability certificate,
5% is taken.
5% is taken.
according to the doctor, what is it?
20 to 25%.
25% disability to the limb.
Yes, my lord, particular limb.
Court are taken,
5%.
how much it should be?
1/3.
8.
8%.
We'll take 8%.
Please, my lord.
So in that case, 14,000 into 12, what is the multiplier?
18, my lord.
18 into 8.
8%. 2,41,000.
It comes to 2,41,920. Then
Amenities is only 5,000.
towards future earning on account of so and so, then loss of amenity. Another 20,000,
Please.
Please, my lord.
that is 25,000. Any future operation?
All of
No evidence.
no evidence.
It comes to 4,04,986.
Contributory negligence
Is there? That we will see.
on the different company.
Ne?
Different New India Assurance Company and other.
Two companies are liable. 70 into 30 ratio, my lord. Ratio is at 30, page number 33, ink page number.
All are served?
Please.
Then we will.
Appeared, my lord.
Huh?
Sitaram Rao appeared party.
But that company is not here. You can file a joint memo. Then
Otherwise,
we'll,
court can pass an order.
that's what I'm saying.
Please.
And this is in respect of this. Then what about the next one?
Next one
Now
is
it comes to then in that case, if the court order.
70%, 30%, 70%.
Legal expenses, 10,000. It comes to 4,14,986 in MFA 7939. Next 7917.
That is the simple in 5,000 is awarded, my lord. Kindly.
What kindly?
It is better to withdraw or to dismiss, my lord.
I leave to the
Simple
analyst.
injury.
No, there should be some basis, not just like that kindly. Alleged accident was held on, so where is that finding with regard to
27 para.
para 27? The petitioner at MEC number sought for compensation of 15 lakhs. Sir.
197.
Medical bill of rupees 197. Having seal and signature of the
They have
attending
not
doctor.
produced one certificate or any medical record. Still, court has granted.
5,000. Will confine that.
Please, my lord.
Confirm that order. Now, where is that? Where do you get this apportionment?
Apportionment, my lord, para 30.
Para 30. It is apportioned at
70-30. 70 on the Sriram General, 30% on the New India.
Sriram General is which respondent?
Sriram
General
third.
is the
Third respondent.
Third respondent 70%.
Please.
And
Sixth respondent.
other respondent, fifth respondent is?
Sixth.
Not fifth, sixth respondent. Sixth respondent 30%. So this issue we need not go because there are no appeal of yours.
Only enhancement is.
The MFA number in this MFA 79 in 49 case, MFA 7939 of 2022 docket order, IA number 1 of 22 is filed to condone the delay of 6 days. Delay condoned. Now the order. agreed with the orders passed in MVC number 397 of 19 dated 8th August 2022. The claimant is before this court seeking enhancement of the compensation. The tribunal, the compensation, yet the claim petition is filed seeking compensation of an amount of rupees 25 lakhs. The tribunal had granted the compensation as per the table given below at para 26 extracted. Learned counsel appearing for the claimant submits that the court had not granted a just and reasonable compensation. It is submitted that when the doctor had deposed that 25% disability to the limb, court had taken only 5% as a disability, which is on the lower side. It is submitted that even under the head of loss of amenities and the loss of income during the later period, the compensation that was awarded is not just and reasonable. Next, the learned counsel appearing for the respondent submits that both the insurance company submits that the court had considered the evidence on record and rightly granted the compensation, and there are no grounds to interfere with the order passed by the tribunal. Next, we're having got the counsels on either side, but it's the material on record. Considering the two injuries, considering the one fracture that's sustained by the claimant and the head of pain and suffering, this court is granting 40,000. Towards the medical expenses, court had rightly granted, no interference is called for. Towards attendant, conveyance, food, nourishment, court had granted 16,000, which is a reasonable amount. Coming to the loss of income during the later period, this accident had taken place in the year 2016 and not 2016, 2019. 2019, considering the hospitalization and the recovery, this court is granting for a period of 3 months, that is 14,000 into 3, 42,000. Coming to the loss of future earning, when the doctor had deposed that it is 25% disability, court ought to have taken 8%. Hence, this court is taking 8% as disability. 14,000 into 12 into 18 into 8 by 100 is 2,41,920. Considering the disability sustained by the claimant at the head of loss of amenities, this court is granting an amount of rupees 25,000. In the light of the law laid down in make love so and so to his legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,14,986. Accordingly, the appeal is partly allowed, enhancing the compensation from an amount of rupees 2,37,416 to 4,14,986. The enhanced amount shall carry 6% interest. And with regard to the apportionment at 70% on the third respondent and 30% on the sixth respondent remains to be the same, and the enhanced amount in the same ratio they are liable to pay.
Entire amount can
According,
entire amount kindly be released, madam. Entire amount kindly be released, madam.
Why earlier there was no such direction?
No, madam.
What is that as per the order?
As per the order, madam. Entire amount released, madam. The on deposit of total compensation amount awarded is once the petitioner is entitled to get released the entire amount, madam.
For 2019, the entire amount, deposited amount, the claimants are at liberty to withdraw. Next one, MFA number 7917 of 2022, I number 1 is filed to condone delay of 15 days. Condone. Then coming to the appeal, the claimant has filed the claim petition seeking compensation. This claim petition is MVC number 398, agreed with the award passed in MVC number 398 of 2019 dated 8th August 2022. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs, and the tribunal had awarded an amount of rupees 5,000 as a global compensation. The court had considered the fact that the claimant has sustained simple injuries and there is no other material placed on record to grant the compensation. When counsel appearing for the claimant submits that, considering the injuries sustained by the claimant, the court ought to have granted the compensation. Next para, having heard, and the learned counsel appearing for the insurance company has made submissions in support of the order impugned. Having heard the counsels on either side, there is a material on record. Considering the fact that the claimant had not produced any documents in support of his case, and still the tribunal had granted an amount of rupees 5,000, this court finds no reasons to interfere. Accordingly, appeal is dismissed. Yes, next. In 49.1, Mr. B.C. Sivanagowda takes notice. 49, in other case, there is already there. It's for, yeah, in both the matters, Mr. B. Sitaram, for respondent number 3, Mr. Sivanagowda takes notice, and for respondent number 6, Mr. B.C. Sitaramaro takes notice, and they shall file the wakalat within 1 week from today. Yes.
Earlier matter 4780. There is no permit.
There is no permit.
But the permit was obtained as per para 53 of the judgment. 10/5/2017 to 9/5/2022. The date of accident was on 24/2017. On that day, there is no permit.
Come to the discussion that's mentioned in the discussion also.
Para 53 make only.
Let's read again. Permit, the registration permit in respect of a particular contract garage shows that respondent number 1 has vehicle having registration number, and the date of validity was 10/5 so and so. The respondent number 1 has permit to ply on all the scheduled routes of state of Karnataka except prohibited routes. Where do you get the
Date
number?
of accident may kindly be seen. That was not discussed. Just say that there is a permit, insurance company liable. But on the date of accident, there was no permit.
Where do you get that there is a permit? The permit is from what date to what date?
10/5/2007, 53 only, 10/5/2017 to 9/5/2022.
And the date of validity, it is about the permit.
Please.
And when is the accident?
Accident is on 24/2017.
24 2017.
No permit.
The agreed with the award passed in which MBC this is?
3.
46.
46, serial number 46.
Part 7 is MEC, sir. 584.
584, madam.
584, madam.
Agreed with the award passed in MBC number 584 of 2018, dated. Why other MBC you are not agreed?
It is pending before
Dated 22nd March 2022. Insurance company is before this court questioning the liability fastened on the insurance company. It's a case of the insurance company that the vehicle was not having a permit to ply the vehicle as on the date of the accident. And in that case, insurance company is not liable to pay the compensation. Then counsel for the insurance company has drawn the attention to para 53 and submits that as per the same, the permit was between 10/5/2017 to 9/5/2022, and the accident had taken place on 24/2017. As such, insurance company is not liable to pay the compensation. Land counsel appearing for the respondent claimant submits that in the light of the law laid down in Amritpal versus
Rani.
Give those citations. Rani versus so and so, and in Amritpal's case, even in those cases, the insurance company is liable to pay the compensation and take for the same from the owner of the vehicle. Next para, having heard the counsel, there is a material on record. The para 53 of the judgment of the award shows that the permit is valid from 10/5/2017 to 9/5/2022. But the accident had taken place on 24/2017, which shows that as on that day there was no permit. In the light of the law laid down in so and so, the above referred cases, still the insurance company is liable to pay the compensation. It put the same from the owner of the vehicle. Accordingly, the appeal of the insurance company is allowed. The amount in deposit shall be forthwith transferred to the trial court. And the insurance company can pay the amount and record the same from the owner of the vehicle. Next,
Serial number 50. Kalyana.
My lord, petition is dismissed, involvement of vehicle.
post after vacation. Admit post for final hearing after vacation. Yes, 51.
51.
Dismissed. Admit post for final hearing.
Serial number 52.
In 51, call for TCR. 52.
52 pertains to Dharwad bench. It has to transfer.
You submitted that this,
Narapanalli comes to.
this matter
Dharwad bench.
pertains to the Dharwad bench.
Please.
Yes, the registry is directed to transfer this file to the Dharwad, to the High Court bench at Dharwad. Yes, next.
Number 53. Nagaraj Reddy.
What about this?
Exoneration.
53.
Huh?
Exonerated. On the ground of involvement.
Insurance company is exonerated. On the ground,
Vehicle involvement is not proved by them.
admit post for final hearing.
Serial number 54. Chandrasekhar for appellant A.N. Krishnaswamy.
Yes, 54.
I'm appearing for the appellant, my lord. In the case of 3191 of 15, it's a case of negligence, my lord.
Admit post for final hearing.
Serial number 55.
Yes, Mr. Yonagoda.
Blood, this is
Case of death, my lord.
case of death.
Death.
You are on the ground of both are on on the amount.
We are on the liability, my lord, but now the defense is not made available.
Which defense?
LMB.
LMB. No, let's see the amount. Give the file.
2013 accident.
In 55.1, IA number 1 of 18 is filed to condone the delay of 820 days on condition. Yes.
2013 is the date of accident, my lord.
Yes.
Deceased was aged about 59 years.
59 years.
Income ought to have been taken 8,000.
Ought to have taken 8,000. Future prospects?
Not at order. Not at consider.
10%
to be added.
10% to be added. So 8,000.
Fair is 9.
8,000 plus 800. 8,800. How many are the claimants?
4. One wife.
Fourth.
Major sons. 1/3.
No, no. The tribunal has rightly consider 1/4.
Deducted by the tribunal, but they are not entitled to get wife is the entitled the. They are not dependent. They are entitled to get only under other.
No, that story we are not going into. 2,200. 6,600 into 12 into
9.
9.
Into 12 into 9. It comes to 7,12,800. You said how many are the dependents? 4. 4 into 4. 1,60,000. 30,000.
9,02,800.
1 minute. Nine lakh 28,000, 2,800. What was the same? It is submitted that the insurance company is ready to pay an amount of rupees 9,02,800, and they'll file a joint memo. Then amount, enhanced amount, the interest rate 6%. The party shall file the joint memo before the Lok Adalat to be held on 22nd.
Please.
Take this. And what about your appeal? We'll discuss it. We will, your appeal.
Appeal has to be dismissed.
The
Transfer and endorsement is not required.
MFA, give the file, same file. Take this order. Appeal is filed. MFA number 3303 of 2016. Appeal is filed, agreed with the orders passed in MAC number. appeal is filed with the insurance company, agreed with the orders passed in MVC number 128 of 2014, dated 10th February 2016. The claim petition is filed seeking compensation of an amount of rupees 25 lakhs for the death of the deceased in the accident. The tribunal had granted compensation of an amount of rupees 6 lakhs 93,000. When it comes to the liability, the tribunal has held that the insurance company is liable to pay the compensation. Then counsel appearing for the insurance company submits that the vehicle involved in the accident is, where do you get that?
First para itself. Tata Ace bearing number KA13A 4936.
What is the vehicle nature?
Tata Ace.
That the vehicle involved is a transport vehicle, and the driver is having no license to drive the transport vehicle. As such, as it amounts to having no license, and the insurance company is not liable to pay the compensation. Then counsel appearing for the respondent submits that in the light of the law laid down with the Honorable Apex Court in Mukund Devigan's case, still the insurance company is liable. Next para. Having heard the counsel so and so and so, the only ground that is raised before this court is with regard to the LMB transport, non-transport. In the light of the settled law, as per the judgment of the Apex Court in Mukund Devigan and so and so, still the insurance company is liable. Accordingly, the appeal of the insurance company is dismissed. Amount and deposit shall be forthwith transferred to the trial court. Next.
56, Shripad V. Shastri.
What about this? Pradeep?
Please.
Enhancement?
Enhancement.
Let's see.
Case of injury, my lord. Date of accident 8/3/2011. Fracture of tibia and fibula.
1 minute. Where is the table?
Para 15, my lord. Internal page 15. Pain and suffering 25,000.
1 minute. There are two fractures.
Please, my lord. Tibia and fibula fracture.
Pain and suffering 60,000.
Was inpatient for 6 days, my lord.
6 days. How much is granted?
5,000 conveyance attendance charges.
Another 1,000. What is this?
Actual medical expense 10,000. Yes.
1 minute. Nourishment. Attendance charges. What is the disability?
30% to the limb, my lord, and 10% to the whole body. MSCT considered 10%.
Then what is the income?
Income taken 4,500, my lord.
Which should have been?
2011, they themselves are claimed that 6,000 per month.
What are taken?
4,500.
So we'll take 6,000. 6,000 into 12. What is the multiplier?
16.
16 into 10. It comes to 1,15,200.
15,200.
Next. Loss of income during the laid up period.
That has 5,000 granted.
Laid up period. Court had granted 5,000. Now we are taking 6,000 into 3.
18,000.
18,000. Then future medical expenses.
10,000 has already granted. Medical
Grant
expenses.
another 10,000, 20,000. Future medical, whatever.
Medical expense. 30,000.
Amenities, loss of amenities not granted.
10,000 about.
Another 10,000 on loss of amenities. So, plus 66,000. It comes to 2,39,200 from 1,71,400. Land council submits that.
Medical expenses 30,000 added, million.
Medical
I think
expense.
2,69,200.
Medical expenses is not added. Medical expenses is how,
30,000.
that is 30,000. Then it becomes
2,69,000.
2,69,000.
69,200.
It is submitted that the insurance company is ready to pay an amount of rupees 2,69,200, and they'll file a memo before the judge file a joint memo before the local adalat on 22nd March.
As against 1,71,400.
Against 1,71,400.
Remaining amount would be enhanced.
That's what the tribunal had granted 1,71,400, and they are ready to pay the lump sum amount of rupees, an amount of rupees 2,69,000. Same joint memo 22nd.
Serial number 57, A N Krishnaswamy, appellant, Sripad B.
Appealing to the
Shastri.
appellant, my lord. Here, we are disputing the ground of the negligence and no driving license, my lord.
Admit post for final hearing.
Serial number 58,
Yes.
58, Sripad B.
What about
Lord, I
this?
have filed the retirement memo pertaining to respond number 2, but it is not attached to the file today.
No, it will adjourn it. Admit post for final hearing. Yes, next.
Serial number 58,
Not 50.
My submission.
Called is 58.
Sorry, ma'am. My submission may be noted because in next.
58, it is submitted that the counsel for the respondent number 2 has filed the retirement memo.
Please.
Yes.
59,
Yes, 59.
Girish B. Builder.
Admit post for final hearing. 60.
Serial number 60,
Yes, 60.
Serial number 60, my lord.
Manap KD Laya.
It's a double appeal, my lord. One appeal has already settled, my lord. 5/2/73 of 2000.
Appeal is already allowed.
They have settled 2 lakh rupees, my lord.
What is that number?
After that, my lord, they have filed this appeal.
How can it be?
Other than this has filed this appeal.
Uh,
That appeal filed by wife.
Then we have to see
I have informed also, my lord.
what they say.
They say I will verify and I will withdraw.
Admit post for final hearing. Post for final hearing. Yes, 61.
Serial number 61. 61.
For the
Seeking
enhancing of
enhancement.
compensation and to fix the liability on insurance company.
Why the liability is fixed on the owner?
No DL case.
Huh?
No DL case, my lord.
DL,
Then pay and recover will apply. Then please come to this calculation.
they have valid DL.
Yes, Mr. Jonagada, help him. Please assist him little. Yes. Come to this is in Kannada. Where is the table?
The table is at, page number 15. Ma'am.
Page number? Yes. Pain and suffering, how much is granted?
I will have.
Come to internal page 13.
30,000.
And if you look at these injuries, fracture distal radius left, tenderness chest, tenderness TL spine, tenderness pelvis. So
There is
previous injury is
22% disability. 22%.
Will grant 40,000 first. Next, what is?
Disability, my lord, they have assessed 22%.
No. How many days he was in hospital?
5 days, my lord.
5 days.
Huh?
5 days.
Court granted?
4 days, my lord.
How much the court granted?
5,300. 5,300 is granted.
6,000 will make it round figure. Yes, next. A loss of income during later period?
It is not
They have
granted.
not taken anything, my lord.
Huh?
Not granted.
Not granted.
It was not
Which year
granted.
is the accident?
5,000 is granted, my lord.
Huh?
Only 65.
Only 65,000.
Which year is the accident?
2014, my lord.
2014, 8,500. 8,500 into 3. How much?
25,500.
Yes.
Doctor exam.
Then loss of income. Then coming to the loss of future income.
Nothing, my lord.
Not granted, my lord.
They have not granted loss of future.
Any evidence of disability?
Examining the doctor,
Why it is disbelieved?
that was also not reflected in the judgment.
Anyhow, the judgment is in Kannada. I can't understand. Admit post for final hearing. 62.
62.
Yes. 62.
Number 62, Gopal Krishna N.
Admit post for final hearing. Yes,
Serial number
next.
63. Serial number 63, O Mahesh.
This also goes for final hearing, admit.
Serial number 64.
This also. Because he's not there, your case can't be.
Maybe a
Case
date.
65.
Serial number 65.
Yes, Krishna
N.
Swami.
Krishna Swami.
On what ground the insurance
Case
company?
of
Huh?
driver had no driving license, my lord. It's a
That's the only thing.
JCP, my lord. The driver had no driving license.
That's what. JCP is not a hazardous vehicle.
TVS is a heavy vehicle, my lord. So that's the reason.
That's what will same apply. Saran Singh will apply. What about the next matter? P. Pramod. You represent Pramod?
Yes, my lord. Yes, my lord, I am relying upon one judgment of this honorable court. JCB is not a JCB is a special equipment used for construction, not a light motor vehicle. They are questioning that the JCB was not. Sorry, my lord.
No. Let us say it requires license. We'll accept there is no license. If there is no license, then pay and recover will apply.
Yes, ma'am.
Pay as far as you are for the owner or for the claimant.
Claimant.
So no problem for you. It is for the owner. So forget that. Then what about the enhancement? That aspect you please argue. Give the file. Please give the file. I mean, where is the table?
Page number 20, my lord. In
Page
page number,
number?
judgment, page number 20. The
What are the
total
injuries
compensation
sustained by
granted
him?
is 13,96,309.
No. What are the injuries sustained by him?
Injuries, disability, permanent disability of 40% to mandible, 50% disability, physical
Counsel,
disability of
Krishna Swami. Where are the injuries?
1 second.
Look at the file. As per the discharge summary, mandible fracture, and doctor had opined that the said injury is grievous in nature. So pain and suffering will grant 60,000. Medical expenses as it is 3,34,709. How many days was in hospital?
46 days.
Where from you get that? From the order, where do you get that? That it is 40 days you are in hospital.
1 minute.
He was in coma about 2 days and remained admitted at St. John's Hospital about 35 days and VCHR Hospital for about 11 days. Totally 46 days he took treatment as in, so 50,000. Then loss of future earning. According to you, what is your income?
9,500.
Is your income, that's the case of the claimant.
No, my lord, 12 to 13,000.
12 to 13,000 according to you. You are relying on the table. Which year is the accident?
2016.
So 9,500 into 12. What is the multiplier?
12.
Multiplier. What is his age?
40.
What you have taken multiplier of?
16.
16.
16 into disability is taken at 60. Any
But 60% is taken
your
for mandible. We have prepared appeal.
Yes, you didn't say that.
That is the problem.
What is the
Mandible fracture, my lord. This is
no,
mandible
understood.
fracture.
Please come to the particular evidence of the doctor. We'll see.
Disability certificate, my lord, para 17 make.
He has suffered a disability to an extent of 75%.
Spinal head.
Wife of injured witnessing condition of her husband. So and so.
Whole body, physical
Gone through
disability
the
to
evidence of
assess by
PW 2
him.
and 3.
My
They
lord, facial
categorically
fractures,
stated that the
spinal-
claimant injured has suffered 40% above fracture of mandible, 50% physical disability, and 100% speech and hearing disability.
But your lordship kindly see the para 18 last parallel,
No,
page
I am
number
looking-
16 only. What they say, he has assessed the disability to whole body and physical disability amount to 50% assessed by him based on the guideline. Medical board, physical
No, the
examination.
petitioner is unable to do his agriculture and hard work at any point of time. He can do simple work. No, then again, from there, you come to the next para, 19.
Please.
19 middle, from middle you please read.
PW1 and PW3, they have categorically stated the claimant injured has suffered 40% about fracture of mandible, 50% physical disability, and 100% speech and hearing disability affected to the entire body. So and so, because of permanent disability, so and so.
So, no speech, no hearing, apart from other things.
Please.
Court had taken 60%. What is wrong?
But, speech and mandible is concerned, my lord.
That's only, it's not alone about mandible. He completely lost because of the injury. He's not able to hear, he is not able to speak. That we have to consider.
But the question is, prior to the accident, what was his status, what not explained before the court?
No, this has happened because of the injury is evidence of the doctor.
No, as per the wound certificate, the head injury is not mentioned. Disability, evolution of promotion, transverse radio, malunion fracture, therefore 40 years. As per the wound certificate, your lordship kindly see, PW2 says, my lord, he has fracture of mandible on
There is a
examination.
head injury also. Further, PW3 deposed that one on account of head injury, his speaking capacity is disabled and is unable to say that if it was improved through given proper treatment.
Please, ma'am, your lordship can
Take 60% only.
no driving license.
So 9,500 into 12 into 16 by 6 into 60 by 100.
Only.
And we have to take future prospects also in case of 60% disability. So 9,500 is ages 36.
Please.
36. 40%.
43 years.
43 years on the date of accident.
So
Therefore, 25%.
in what is the variation for that? We take 40, 50 in case of.
If up to 40 millard, we will take for non-earning person 40%, earning person
50%.
proved income 50%.
For other cities, 25 only for all.
25, then after 50 millard, 10, 15.
In case till 40, there is a variation between a gun. 10%.
Correct.
In case of 25%, it should be 35. I think.
20%.
Huh?
30% fixed income.
This person is doing what?
Agriculture. Millard. Agriculture is earning 1 lakh.
So 9,500, 25%. Yes, Mr. Sivanagoda.
Please,
25%.
Please.
It would be 2,375. It comes to 11,875 into 12 into 16 into 60 divided by 100. It comes to 13 lakhs 68,000.
14. My lord, 14,
Multiplied
my lord,
14.
14.
Oh, I took the multiplier 16. Trial
43
court had
years,
taken-
my lord.
Huh?
43 years.
So we'll do it. It is 14 multiplier.
Please.
11,875. It's coming to 11 lakhs 97,000. Then loss of future amenities, disability, loss of amenities. Yes,
Amenities only 40,000 is granted.
Not reasonable. 60% disability, one. Future medical expenses,
30,000 is granted. 300,000.
it comes to 17 lakhs 71,709. What is awarded is 13 lakhs 96,309. Yes, judicial order. The present appeal is filed. Appeal is filed with the insurance company. Agreed with orders passed in MBC number 757 of 2016, dated 5th July 2018. The claim petition is filed seeking compensation of an amount of rupees. How much is claimed? Seeking compensation for the injuries sustained by the claimant in the road traffic accident. It is a case that on 13/2/2016 at about 10:30 a.m., the claimant along with one Chandrappa was proceeding in a motorcycle. When they reached near the village, at that time the driver of the JCB moved its bucket without any signal and hit to the head of the petition claimant. As a result, he sustained injuries to the lumbar region, spine, abdomen, right thigh. He took treatment at the government hospital and other major hospitals by spending an amount of rupees 20 lakhs towards the medical expenses. He is not in a position to identify any person or position to make movement of his lips, lost his speech, he has lost his mental strength. He is aged 41 years. He was an agriculturist and used to earn rupees 10 lakhs per annum. Due to the loss of entire memory, he became mentally unsound, cannot do any work, is a bedridden, and his wife and son are looking after his day-to-day life. The tribunal had granted the compensation of an amount of rupees 13 lakhs 96,309. Coming to the liability,
The JCP driver did not possess the driving
well, this is also a transport, non-transport, Mr. Shivanagoda,
Endorsement is requirement
for the crane.
JCB. There is a judgment of our on by court.
The court had considered it as a transport, non-transport endorsement and has held that the insurance company is liable to pay the compensation. Agreed thereby, the insurance company is before this court both on the quantum and the liability. The claimant is before this court seeking enhancement of the compensation by filing MFA Prop 9 of 2019. Hence, both the petitions are disposed of by way of the common order. First, coming to the liability, the vehicle that is involved is a JCB and that requires the special license. And admittedly, in this case, the said vehicle is not having the driver of the said crane was not having the special kind of license. In that view of the matter, the insurance company, the principle of pay and recover applies, and the insurance company is liable to pay the compensation and recover the same from the owner of the vehicle. Coming to the compensation, it is the evidence of the doctor that because of the injuries sustained by him, on account of head injury, his speaking capacity is disabled. He is unable to say that if it was, and he is unable to say whether it will improve through given proper treatment. He has assessed disability to the whole body and physical disability amounting to 50%, assessed by him based on guidelines issued by the medical board and also physical examination of the claimant. He further deposed that the claimant is unable to do his agriculture and hard work at any point of time, but he can do only simple work. It is stated that the claimant is partially disabled by physically and 100% disabled about with regard to hearing and speaking. And the doctor also denied that the disability has to be considered whole body disability as 1/3. The tribunal had taken the disability at 60% and the income at 8,000. When counsel appearing for the claimant submits that the accident had taken place in the year 2016, as such the income has to be taken at 9,500. Further, concerning the disability of the 60%, what the future prospects ought to have been granted. Even at the other heads also, the compensation that is awarded by the tribunal is not just and reasonable. Next para. When counsel appearing for the insurance company submits that the insurance company is not liable to pay the compensation, and the compensation that is awarded by the tribunal on all the heads is on the higher side. It is submitted that the disability, taking the disability at 60% is without any basis, and the same needs to be reduced. And next para, having heard the counsels on either side, but submitted non-record. The first coming to the liability issue, considering the fact that the vehicle is a special class of vehicle and the claimant and the driver was not having a driving license to drive the said special class of vehicle. As such, it amounts to violation of the terms and conditions of the policy, and in the light of the law laid down in Swaran Singh's case, the principle of pay and recover will apply. Then coming to the compensation, the claimant had sustained the grievous injury. Hence, under the head of pain and suffering, this court is granting 60,000. Coming to the medical expenses as ordered by the court, 3,34,709, and no interference is called for. Considering the hospitalization of about more than 46 days, under the head of conveyance, nourishment, and attendant charges, this court is granting 50,000. Then coming to the loss of future earning, as this is an accident of 2016, and as there is no evidence available on record to show the income, as per the as per the chart prepared by the Legal Services Authority, the notional income is taken at 9,500. Then coming to the disability, as the evidence of the doctor clearly shows that because of the injuries sustained by him in the accident, he completely is not able to hear or speaking skills as well as hearing ability, both completely, either he is not able to speak or not able to hear. And in those circumstances, this court is of the view that the disability of 60% is correctly taken. Future prospects for 9,500 would come to at 25% will come to 2,375. That is 11,875 into 12 into 14 into 60 by 100 is 11,97,000. Considering the 60% disability, this court is granting the loss of amenities at 1 lakh, and the future medical expenses, the court had granted how much? 30,000. 30,000. And in the light of the law laid down in Mekala versus so and so, legal expenses 10,000. And accordingly, the claimant is entitled for an amount of rupees 17,81,709. The appeal of the claimant is allowed, enhancing the compensation from 13,96,309 to 17,81,709. And the CROB is partly allowed, and the enhanced amount shall carry 6% interest. The appeal of the insurance company is partly allowed by applying the principle of pay and recover. The insurance company shall pay and record the same from the owner of the vehicle. Amount in deposit shall be forthwith transferred. Next.
Much obliged, my lord.
It's okay.
Serial number 66.
Yes, what about this?
My lord, serial number 66 and 67,
Huh.
both are arising out of a single judgment, my lord.
Huh.
One appeal is filed by the claimant, my lord, and one appeal filed by the insurance company, my lord, by challenging the quantum, my lord. In here also, my lord, I am filing appeal by enhancement of the, seeking enhancement of the.
Reassessment of the compensation.
Let's do.
Please,
Give it.
2007,
Give the file.
2017 accident.
2017 accident.
Yes, my lord.
Wife and the children are the
Case of death.
Case of death, my lord, 4 members.
Aadhaar card. He was aged about 74 years.
As per the Aadhaar card. As per the PM report,
52, my lord.
that we have to take.
No, Aadhaar card they have produced before the court. He is aged about 72 years.
What is the age of the children and the wife?
Please.
Correct, wife is 48 years.
In cross-examination, my lord, the claimant stated that some.
Document was produced by the claimant. Exhibit P10 was produced by the claimant to show that he is the person. His age is. With such being the case, my lord, admitted fact, can it be proved once again?
My lord, the Aadhaar card, purpose of the Aadhaar card only to show the identification of the person, but not
Yes,
the.
so PM report says how much?
52, my lord.
We will take
That
52.
was taken, my lord.
We will take that, it's rightly taken.
Yes, my lord.
But,
And
another one
year
is
of accident in 2017.
Yes, my lord.
11,000 is the
my lord.
income.
1/3 is
And
deducted.
1/4 has to be
How much
deducted.
the court had taken?
4 members, 1/3, my lord. But since 4 members.
Salary.
No, 8,000, my lord.
Two major sons and married daughters are
So-
the claimant. They are not depending on the income of the deceased. Therefore,
What is the evidence let in by you? What is the evidence? What is their case with regard to the dependency?
they have not accused, they are depending.
They must have said so.
No documents were placed.
No, what document they will say that every day is
At
giving
least
him 5,000?
Aadhaar card, to say that, or the ration card, to say that they are residing with them, they are assessing.
What is that? Seema Rani?
That's what Seema Rani
Seema Rani
said.
didn't say anything like that.
No, Marat, he says that they have given the evidence to that she was residing with their parents' house.
What is that prior to that? What is that case? Seema Rani, what is that case? What is the case referred in Seema Rani? Huh?
Peli Ram case. In
Peli
that
Ram's case.
In that case also, Marat, the special circumstances, the compensation was granted. Since his father was taken some loan from the bank, they have given the undertaking before the court stating that, Marat, they will not claim the amount from the.
Let us read it, the facts of the claim petition. The dependents of the deceased were released as so and so, so and so. Prior to the accident, the deceased was hale and healthy, doing coolie work and earning income of rupees 20,000 per month, and he was only the earning member in their family. Due to the untimely death, they are put to deep mental shock and agony on account so and so. Now, let's come to the age. So 34 years, agriculturist. Next, Ramesh, 32 years. Another one is 30 years. All are resident of, the first three are residents of Loki Kere village, Davangere Taluk. So,
Daughters are not residing.
oh, why not?
When they have got married, Marat, still they are residing, they have to produce some document. Either some.
No,
document-
residing in the same village, they may be taking financial assistance from the father. Why not? If he is hale and healthy, he
That
would
is love
contribute
and
to
affection,
them.
Marat.
Huh?
That is love and affection. Not
No,
the-
no, no, that is love and affection is consortium, that is different. This is, if he is there, you would regularly contribute to them. You will take care of them, that's their case. He's the only earning, others are not earning.
If the married daughter's husband was not taken care.
No, no, please look at it.
Please.
No, 1, 2, 3 are residing in the same village.
Please.
Fourth one is not residing in the village. Even if you take 3 or 4,
3, 1/3.
1/3 would be the same.
No, what my respectful argument, Marat, wife alone is the dependent, therefore 50% has to be deducted.
No, it's completely diluted. 1/4 or 1/3.
One third taken by the tribunal, my lord. My prayer is, my lord, kindly, it has to be taken 1/4, since 4 members, my lord. If 4 members, 1/4 has to be taken, my lord.
We'll take 1/4. It comes to 2750. 8,250 into 12, what is the multiplier?
11, my lord.
52.
11, my lord.
38 years son
Hmm.
or 52. You'll have to kindly consider that 12 years can the child can born.
Everybody's age is like that.
Hala. So whether it is possible.
Everybody's, no, like his Aadhaar card.
Science also it is not possible.
No, then please understand one aspect. Whenever there is no other evidence on record,
No, there is an evidence.
please,
in
one
this case.
minute.
Please.
We say whatever that is as per the postmortem report, whatever is it, we have been considering it as age. When there is a dispute, even in a dispute also. So why we shouldn't consider the postmortem report and the age as 52?
The possibility has to be looked into while considering that the document is made.
And
available
definitely
to say that
72 possibility
he
also.
is about 74 years. There is a document, Aadhaar card is placed.
He can't take 74.
At least in mid.
What is middle? How can?
52 and 74. Some, because they themselves will do, but even according to the science, it is not possible to hold a son at the age of.
What is
12
this
years.
age? 34. We'll take 54.
Please.
One multiplier will be required.
Hmm?
Same multiplier, my lord.
Same.
Huh?
Same multiplier.
Well, they never tried by filing any application to summon any
50
document.
No, 51 to 55 is the same
Same
multiplier,
multiplier,
11.
my lord.
If it is 56, it is 9. Then we'll take 56. It comes to 8 lakh 91,000 and 5. You said these are 4 in number.
Yes, my lord.
It comes to 1,60,000.
Future prospectus, my lord. Death case.
His age is 56.
10%.
That is not taken.
10%.
11,000 for the 10% means 1,100. 11,000, 1,100 is 12,000. That is 12,100. From 12,100, 100 into 1 divided by 4, 3,025. It comes to 9,075. So 9,075 into 12 into 9. 9 lakh 80,000. 100. One and 1,60,000 to best 30,000. Plus 30,000. It comes to 11 lakh 70,100. What is awarded?
7,74,000.
7 lakh
74,000.
70,000.
74, 74, my lord.
7 lakh 74,000.
Yes, ma'am.
It is submitted by the insurance company that they're ready to pay an amount of rupees 11 lakh 70,100 from that of that is granted by the trial court, that is 7 lakh 74,000, and they'll file a joint memo on 22nd. Yes. Then what about the remaining matters?
One kind submission.
Yeah, Tuesday, maybe.
We'll take it on Monday.
Please.
So that we'll continue.
That's serial number
73, my lord.
73.
70?
73.
73. A morning you are saying.
Yes.
ma'am.
Appeal and cross objections both are.
You want to withdraw?
Both are
Both the
withdrawing.
insurance company, memos are filed before the court stating that both the insurance company filed a memo seeking to withdraw, as well as the claimant has has also filed a memo to withdraw MFA crop. Accordingly, both the memos are taken and appeal and the MFA crop are dismissed as withdrawn. Yes.
My appeal, my lord, amount in deposit may be transferred.
Amount in deposit shall be forthwith transferred to
Number
the
83. ma'am.
80.
83.
For the appellant, my lordship.
10 lakh 50,000.
10 lakhs.
10 lakhs 50,000.
It is submitted that the insurance company is ready to pay an amount of rupees 10 lakhs 50,000, and a memo will be, a joint memo will be filed before the Lok Adalat on 22nd. Yes.
Serial number 77, my lord. It may be admitted I have to produce some more documents. Kindly admit the matter and post matter for filing.
No, that you have to file there, not here.
I will file in the office.
MFS at 77. Item number 77, admit post for final hearing.
Serial number 88, your lordship, contributory negligence, set aside. Therefore, your lordship.
88, admit post for final hearing.
3 cases.
Let serial number 86.
1 minute. 88, admit post for final hearing. No, there is still no final hearing. Please wait. Notice is still to be issued to R3. Process has to be paid in 88. In 88, 88.1.
Mandoda is the pair, your lordship.
R3. R3. R3, nobody is appearing.
Serial number 88.
Yes, I am referring to 88.1.
Point
88.1, the process shall be paid within a week for service of notice to R3, or else appeal against R3 shall stand dismissed. Then 88.2, IA number 1 of 21 is filed to condone the delay of 33 days in filing. Same condoned. Yes.
Let serial number 112, my lord.
112, yes.
In this case, in Krab appeal for the claimant, my lord. In that case, like a notice not duly served to respond number 2. I made applied an application substitute service. Application was not listed.
112.
112.2.
Notice to whom?
For R2 is the owner of the vehicle, my lord.
Liability is on.
Liability that disputing by the insurance company.
No, 112 is Mr. O Mahesh.
Oh my God. Krab, I am appearing for that.
Huh?
There are 2 cases, my lord. In Krab, he filed by the claimant, my lord. In that case, the notice not served to the respond number 2 is the owner of the vehicle. I filed an application substitute service.
Where is that?
Application was not put up.
This matter, 112, list on Monday, on the day that the registry shall place the application filed by the appellant for substituted service of notice. Yes.
Not 79.
Wednesday. 79.
79. Claim company appeal is also there, my lord. In that.
70?
79.
79.
3735 of 21.
79, admit post for final hearing along with
3735 of 2021.
3735 of 2021. Yes. 80?
Tribunal has awarded 5,39,704 plus 8%.
Hmm.
Now it is reduced to 4,39,704.
What we'll do is, if you are, we'll refer it to the local for a joint memo. We'll try. If it's not happened, it is submitted that the insurance company is ready to pay
4,39,704 with 6% interest as against the.
in addition to or total
Against the award of.
as against the award of
Award passed by the tribunal.
tribunal. The insurance company is ready to pay an amount of rupees 4 lakh.
4,39,704.
704. Let's just for filing of joint memo, let's just matter on 22nd before the Lok Adalat.
Please.
Yes, you are saying something? No other number.
38.
Sure. 38 is, let it be. Give some other date.
No, Monday.
Appear for 38, my appear for appellate claimant, my lord.
38.
It will come on Monday.
Monday.
So how many matters are now left in your list? About 30? or more than that? 50? How many are listed today?
134.
134.
Hmm.
Some cases are urgent due to,
Various reasons.
still also it's very good.
How many are settled? How many are for the joint memo?
More than 12. 10 to 12. Now they are submitted.
26 are running those.
So we'll have it on Monday. And some more, any other cases, you can tell this, the Raghu and all that, no? They're listed. So Monday also your matters. And some other matters are coming on.
Which are not listed.
From Monday, other judges on leave, family matters will also come to this court.
Or it may be out on Monday.
Tuesday.
No, we will try to, no, we'll say 2:30, Monday at 2:30. No, problem is if I give the time 2:30, then if it reaches before, nobody will be there. Let it be, we'll see accordingly. In one matter, I said there shall be pay and recover. For pay and recover, there should be a judicial order. What will happen in Lok Adalat?
We have several cases.
Like that? How can that be? Because how can the claimant say pay and recover, and how can you people settle on something with regard to the owner of the vehicle? Claimant and insurance company.
Only a paper degree.
But I think as far as that is concerned, it should be on a judicial side.
Correct.
But not
It is proper.
only date given matters from Monday. No other matters. Don't add any other matter. Only this Lok Adalat ones. Memo moved, then post.
Pune, 26. But she discussed some of the cases she has posted for usual court ಅಂದ್ರೆ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೂಡ ನೋಡಿ ಸದಾನಂದ ಅವರೇ ಈ ಫೈಲ್ಸ್ ತೆಗಿತೀರಾ ಅವ್ರು ಆಗಿದಾವ ಒಂದು ನಿಮಿಷ ಇರೋ ಇಲ್ಲ ನೀವು ಹೇಳ್ತೀರಾ ನಾನು ಬರೀಲ್ಲ ನೀನು ಬರೀ ನಾನು ಡಿಸ್ಮಿಸ್ ವಿಡ್ರಾನ್ ಬರೆಯಕ್ತೀನಿ ಡಿಸ್ಮಿಸ್ ವಿಡ್ರಾನ್ ಇದು ಅದು ಬಿಡಿ ಅದು ಅವ್ರಿಗೆ ನಿಮಿಷ ಡಿಸ್ಮಿಸ್ ವಿಡ್ರಾನ್ ಇಲ್ಲಿಟ್ಟಿದ್ದೀರಾ ಫೈಲ್ ಕೊಡಿ ಅದು ಫೈಲ್ ಕೊಡಿ ಅಲ್ಲ 73 ಅಲ್ಲ 80 73 73 ಒಂದು ಕೊಡಿ ಇರುತ್ತೆ
ನಮ್ಮ ಫೈಲ್ ಎತ್ಕೊಳ್ಳೋ ಅಂತ ಹೇಳ್ರಿ ಫೈಲ್ ಎಲ್ಲ ಅಲ್ಲಿ ಕೆಳಗೆ
ಇಲ್ಲ ಸರ್
we had already discussed so many cases. ಒಂದು ಕಡೆಯಿಂದ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್
ಇದ್ರಾಗ ಇಟ್ಕೊಳ್ತೀವಿ ಇದ್ರಾಗ
ಆಗಿದೆಲ್ಲ ಈ ಕಡೆ ಇಟ್ಬಿಟ್ಟಿದೆ ಈಗ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ
ಈ ತಿಂಗಳು ರೀಚ್ ಆಗಿಲ್ಲ ಇದಾಯ್ತು
66
ಆಗದವಲ್ಲ ಇಲ್ಲೇ ಹೋಗ್ತಾರೆ
ಮತ್ತೆ ಇನ್ಯಾವ ಹೊತ್ಕೊಂಡವನ್ ಯಾರು ಇಲ್ಲಿ ಗಂಟ ಬಾ ಅಂತ ರೀಚ್ ಆಗಿಲ್ಲ ಅಣ್ಣ ರಿಮೈನಿಂಗ್ ಎಲ್ಲ ನಿಮ್ಗೆ ಮಂಡೆ ಬರ್ತದೆ ತಗೊಂಡೋಗೋಣ ಇಷ್ಟು ತಗೊಂಡೋಗ್ತೀನಿ ಇದು ತಗೋಬೇಕು ಇವು ಮಾತ್ರ ಇಲ್ಲ ಇವು ರೀಚ್ ಆಗ್ತದೆ ಇದು ಇವೆರಡು ಇಲ್ಲ ಇಷ್ಟು ಅಷ್ಟು ತಗೊಳ್ಳಿ ಇವು ಇಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಅಥವಾ ಬೇರೆ ಕಡೆ ಇರ್ತಪ್ಪ. ಅದಕ್ಕೆ ಅವು ತಿರ್ಗಾ ಒಪ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಅಂತ ಬಹಳ ಕಷ್ಟ.
ಇನ್ನೂ ಇದೆ ಇಲ್ಲಿ ಬರೀತೇನೆ.
ಸಪ್ರೇಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇವತ್ತು ಮಾಡಿಸ್ಬೇಕು ಅಷ್ಟೇ.
ಇವಾಗ ಹಿಂಗೆಲ್ಲ ನಾವು ಬರಿಬೇಕಾ ಲಿಸ್ಟ್?
ಅಲ್ಲಿ ಬರೀ ಅರ್ಜೆಂಟ್ ಮಾಡು, ರಿಪೀಟ್ ಕೊಡೋಣ ಫೈಲ್ ಇಟ್ಕೊಂಡು. ಅರ್ಜೆಂಟ್ ನಾವೇ ಬರಿಬೇಕಾ ಅದು?
ಬೇಡ
ಅವತ್ತೇನಾಯ್ತದ ನೋಡ್ಕೊಂಡು
ಏನಾದ್ರು ಗೊತ್ತಾಗಲ್ಲ.
PCR ಎಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ. PCR ಒಂದು ಕಂಡಲ್ವಾ? ಶನಿವಾರ ಇಂಡಸ್ಟ್ಮೆಂಟ್ ಬರ್ಕೊಳ್ಳೋಣ ಅಂತ ಹೋಗಿದ್ದು. ಇದಂಗೆ ಕೊಡ್ಲಿ.
ಇವಾಗ ಬೇರೆದ್ ಹಾಕಿದ್ರೆ ಇದ್ ಮೇಲ್ ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಬೇರೆದ್ ಹಾಕಿದ್ರೆ ಅಲ್ಲ ಇದಕ್ ಸೇರ್ಸ್ಬಿಟ್ರೆ ಅವರು ಇದಕ್ಕೆ
ಏನ್ ಬೇಕು ಸರ್? ಏನ್ ಅವ್ರು ವೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ? ಅದು ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಹೋಯ್ತು ಕೋರ್ಟ್ ಮುಂದೆ. ಅದು ಏನು ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ನೀವು ಇರ್ಲಿಲ್ವಲ್ಲ, ಪ್ರೆಸೆಂಟ್ ಇಲ್ಲ. ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅದೇ ಎಷ್ಟೊಂದೆಲ್ಲ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕಿದ್ರಲ್ಲ ಸರ್. ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರ್ಯಾರು ಬಂದು ಸಬ್ಮಿಟ್ ಮಾಡಿ ರೆಡಿ ಆದ್ರು ಅದೆಲ್ಲ ಆಯ್ತು. ಸೆಟ್ಲ್ಮೆಂಟ್ ಬಿಫೋರ್ ಇದು ನೀವು ಬಂದಿಲ್ಲ. ಅದು ಯೂಶುವಲ್ ಕೋರ್ಸ್ ಅಲ್ಲಿ
Madam, list to serial